Kayla, let me know. Thank you. All right, welcome to Economic Matters. It's February 15th, 2022. We're going to be starting with bill hearings today to let everybody listening know, number one, that the chat is only for members, so please do not enter anything into the chat. I would ask that you keep yourself muted until you are unmuted by myself or Kayla. For everyone else listening, please note that this is a live ball. Once there is a hearing, it is a live bill, meaning do not delay or wait to get your amendments in, to get your comments in, and preferably you would have made them during the hearing. And our subcommittees are not going to be used as public hearings because the public is listening now. So again, with all that being said, we're going to start with our first bill, the wonderful Delegate Pena-Melnick, House Bill 533. Madam Vice Chair.
Thank you, Mr. Chairman, and good afternoon. It is an honor to be in your committee. Vice Chair Crosby and members of the Economic Matters Committee. I'm pleased to present to you House Bill 533. This bill will help fill critical labor shortages by expanding access to occupational and professional licenses to immigrants, regardless of their legal status, as long as they fulfill the educational and professional requirements for the particular license. We are currently in a workforce crisis that we have long been trying to prevent, causing immense strain to our workers and our economy. Expanding access to occupational licensure will provide immediate relief, helping those who have been helping us navigate the pandemic for over 2 years. Hospitals are currently experiencing a crisis staffing situation, the worst in over 570 days of fighting the pandemic. Nursing homes alone have seen its industry's employment level drop by 14%. That's 221,000 jobs since the beginning of the pandemic. Teachers and support staff are exhausted. Maryland's largest school district, Montgomery County, has vacancies for 325 teachers, about 105 para-educators, and nearly 100 other support staff. And this is the case in every other county, and we have 23 counties in Baltimore City. There are not enough substitute teachers to provide coverage during staff absences due to COVID-19 infections. Shortages of skilled laborers in Maryland are causing some construction projects to cost millions of dollars more than original estimates. Everyone is impacted due to workforce shortages, our sick, our children, and our communities. We need trained, qualified people to step into these positions. Expanding access to occupational licensure would provide an employment pool of quality and dynamic individuals while diversifying workforces to better serve our communities in Maryland. This bill does that. In Maryland, we allowed undocumented students to get in-state tuition. They go through college. They start usually in the two-year colleges, the community colleges. Then they go on to the four-year colleges. And what happens is that when they graduate, they can get a license. They can sit through the exam, and they have gone through the education. This bill will expand licensure to all Marylanders, and it will result in economic benefits to the state and local communities. I ask a favorable report. I want to mention the following letters. I want the committee respectfully to look at the letter from the Board of Nursing, which basically they said that licensure applicants, nursing licensure applicants are denied if they do not have a social security number. Under existing law, the board is required to collect and verify social security submitted in part of the licensure and certification process. If they don't have it, they can't get the license, even though they have completed their program. So the board says in its letter that current inconsistencies would exclude immigrants who have lawfully obtained an ITIN holder. So ITIN holders are people that have permission from the federal government. They have given them that number, and they actually work and they pay taxes. And in Maryland last year, almost 89,000 ITIN holders actually pay taxes, almost 140 million people. So these people that are ITIN holders are people that are going and getting their paperwork, and they're not able to get their licensure because that is the current law. It doesn't allow it. So I'm asking for this to be fixed I also would like to point to the letter from the judiciary is the only opposition. And then there's also two private individuals in this bill. And the what they would like is for professional requirements says should include character and fitness and all other aspects of the bar application. And they just want clarifying language. And I would agree with that. There's also support from the Maryland Hospital Association, from the nursing homes, from MECI, and I ask for a favorable report. Thank you so much for your time and attention. I really appreciate it.
Thank you, Madam Vice Chair. I see one hand up from Delegate Impalaria. Rick, do you want to wait or you want to just ask the good Vice Chair? You want to wait? Okay, thank you. Next we have testifying is Iwalawa Ogundana.
Thank you, Chair C.T. Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. My name is Ewalua Ogundana. I am a graduate student at the University of Maryland, College Park, and I am also one of the 7,470 Deferred Action for Childhood Arrival, otherwise known as DACA recipients in Maryland, an immigration status that partially protects individuals who came to the U.S. as children. There are 13,000 other immigrants in Maryland who are eligible for DACA, but because former President Trump ended the status in 2017, and a federal judge in Texas recently ruled that DACA was adopted illegally, a number of applications have been backlogged and no new applications have been accepted since July of last year. As a result, these immigrants cannot obtain Social Security numbers, which are needed to obtain licensure in Maryland in fields such as nursing, dentistry, medicine, accounting, etc. So passing this legislation will benefit Maryland in 4 significant ways. 1, this legislation will alleviate the roadblocks to obtaining professional licenses and encourage more undocumented students to complete their education so that they do not go to other fields simply because those fields don't require licensure. It would be a loss to Maryland's workforce if these students pursue other fields simply because the state bars them from obtaining professional licenses. 2, it is inconsistent to limit specific licenses from undocumented immigrants if the actual operation of that profession does not require citizenship. 3, Maryland already allows eligible undocumented students to pay in-state tuition, and they can attend community college tuition-free under Maryland's Community College Promise Scholarship Program. So passing this legislation will be consistent with past policies that have helped undocumented immigrants thus far. 4, lastly, with staff shortages in hospitals across the state, this legislation would bring significant relief to Maryland's healthcare system as more immigrants could obtain necessary licenses to become healthcare professionals and continue fighting against COVID-19. So I respectfully ask the committee to give HB 533 a favorable report. Thank you.
Thank you, Rick. Do you have a question or you still want to wait?
There we go. I'm unmuted. All right. Thank you, Delegate Minnick, for bringing this bill. So, I agree with you. There is a workforce shortage. And in the medical field and many other fields, that shortage is caused because people have been fired for refusing to get their vaccine, their body, their choice. They don't want the vaccine, but they've been fired for their jobs. And I think that's an issue that we really need to work on first. And do you believe that with passing a bill like this, we should include doctors and lawyers, people who come here from other countries illegally, but they're doctors, they are lawyers, they are accountants, they are professionals in a professional white collar field. Should they not be included in this bill?
They are included in this bill if you have obtained your education and your professional requirement and have gone through a course here in Maryland. Okay, those are the people that are included in this bill. And if I may, as you know, good delegate, we've been friends for many years.
Yeah.
I sit on the Health and Government Operations Committee, and as the vice chair and the chair of public health, I can tell you that the workforce is not entirely due to people that have not gotten vaccination. That's a very small number. The workforce is due because we are overwhelmed. The system is overwhelmed by the number of sick people that are in the hospitals. As you know, the hospitals are operating in emergency matter right now. And not only that, they're exhausted, delegate. They're working nonstop without a break. They are, they have had it. Some people have decided not to renew their license because they are exhausted and they're burned out. And that is really a big problem in the workforce. And we don't have enough people that are nurses and doctors presently, and which is why a lot of the boards have sort of relaxed a little with some of the licenses because we have a shortage. So there are many factors why we have a shortage presently.
Yeah, and so you would agree that whether the number's big or small, a minority of people or not, there are highly qualified people, young women, young men who have decided they want to have children. They don't want to take a chance of taking an untested vaccine that could affect that. You have people who were nearing their retirement and rather be forced to take a vaccine, they're retiring early. And if we're going to fix a problem, we need to fix the entire problem. These people need to be able to get back to work. And if this is another solution, it's another solution, but we can't leave them beside on the roadside, laying on the roadside and losing their jobs and then being replaced from people who came to this country illegally. And I think people should have a right to work. But I think if we're going to have people go back to work, first we need to get the people back to work that we took their jobs away from them by government, by forcing a vaccine, and then bring these other people on if that's what the solution is. But I don't think we should leave the other people ignored.
Well,
I guess he'll end that with, isn't that so?
Yep.
Isn't that so? I will respectfully disagree. My bill deals with one issue. This is just another tool in the toolbox to help this industry that is in a crisis.
Yep.
But I will say that we all are very interested in your My Body, My Choice. Keep that in mind, sir. I'm sure we'll be hearing that again soon. Thank you.
Thank you, Mr. Chairman. Thank you, Delegate.
And the next presenter we have is Edith Perry.
No, she's not. That was a mistake.
Joseph Matos.
Yes, Mr. Chairman, thank you so much. Thank you, Chair Wilson, Vice Chair Crosby, and members of the committee. I'm Joe DeMatos. I'm president of the Health Facilities Association of Maryland. We represent the majority of skilled nursing and rehab centers in Maryland, as well as over 36 assisted living providers. We're speaking today in strong support of House Bill 533. You have our written testimony, so I'll please just summarize. Let me just start by saying that in this prolonged time of workforce crisis, no trained individual should be turned away because of their immigration status. In the same way in Maryland that we don't turn away these Marylanders for their educational opportunities. The current workforce crisis in this pandemic predates the pandemic. We had a shortage of doctors because we have a shortage of slots at universities. We have a shortage of nurses because we have a shortage of nurse educators to train nurses, and so on down the continuum. The pressures of the pandemic dramatically worsened this crisis. Last year, the Board of Nursing reported 40,000 individuals chose not to renew their licenses. In this last surge, we learned that there's no hospital workforce or physician office workforce or nursing home workforce. There is one workforce, and it is incredibly shorthanded, and we're all pulling from that same workforce. Going forward, the workforce challenge that we're presently in will be measured in years, not in months. We need all the caring hearts and trained hands we can get. And for that reason, we're asking for a favorable report on House Bill 533. Thank you.
I see no questions. We're going to our next presenter. It's Rocio Fredro Mata. Wow.
Hi, everyone. I would like to confirm the positive impact of this bill for the economic growth of the state of Maryland. As the coordinator for immigrant and undocumented student life at the University of Maryland, I assist undocumented students every day with their education and career goals. As undocumented students approach their senior year, they're invested in pursuing either graduate education or career prospects within the state of Maryland. Unlike most of their peers, these students have prohibitions of obtaining professional licenses as a result of their immigration status. Licenses such as, but not limited to, nursing, psychology, occupational therapy, architecture, teaching, CPAs, CNAs, and even cosmetology require a social security number. This requirement could be changed easily to require an ITIN number instead. These restrictions impact future professionals that need this licensure to practice and open businesses for said practices. Currently, we have students in all types of programs at Maryland, architecture, business, and in the medical field who are interested in continuing to work in Maryland. Not having this ability to obtain professional licensure will most likely force these students to go to other states such as California or New Jersey in order to be able to practice what they studied for. I believe this will diminish our exceptional workforce that originates in Maryland and is counterproductive to the efforts that the state of Maryland already provides these students. Maryland already invests in students with the Maryland Dream Act, with the MISFA, with the College Promise programs, and our students would like to continue to reside and work in their home state of Maryland. They would like to contribute to the state's economy and become engaged leaders. The Maryland Dream Act provided the first step to a student's educational journey, and this bill will provide the necessary action to transition students from college into their professional careers. I believe this will help transform the Maryland economy positively, and I ask for a favorable report.
Seeing no questions, move on to our final witness, Monica Guerrero Vasquez.
Hi, good afternoon, Delegate C.T. Wilson and members of the House of Economic Matters. My name is Monica Guerrero Vasquez. I live in Baltimore City, and I'm the Executive Director of Centro Sol, the Center for Health and Opportunities for Latinos. I am here to support HB 533, Occupations and Professions Licenses, Certificates, and Registrations. Our mission is to promote equity in health and opportunities for all Baltimoreans, including immigrants. Since 2014, Centro Sol has run a youth program, and over 150 youth have graduated high school, pursued their science degrees, including areas in healthcare and engineering, thanks to the policies allowing them to access college education. However, many are not able to pursue their professional licenses, leaving them in a disadvantaged position for career development. This is a missing opportunity to promote diversity and inclusion of great talents in our state while the population continues to diversify, but we're not able to provide the culturally appropriate services that they need. These youth often ask us, what is the point of working so hard if we're not going to be able to get our licenses? This bill has the potential to supply for the staff shortages that we just mentioned, diversify the workforce, and brighten the lives of our professionals and the future of our state. For those reasons, we urge you to vote in favor of HB 533. Thank you for the opportunity to speak in front of you.
Question from Delegate Chi.
Thank you, Mr. Chair. I actually just want to commend the sponsor for introducing this very smart bill. That is great in every way. I cannot think of any downside. I think it benefits, it empowers communities, it benefits our economy, it not only fixes an immediate problem, but it fixes the pipeline problem. As our community becomes more, and America in general really becomes more diverse, we need service providers and professionals who are culturally competent and linguistically accessible as professionals because it's efficient. And I know many hospitals and healthcare CEOs and executives are scratching their heads how to hire large cadres of people who can speak different languages and understand different religions. And so this is a brilliant move, and I'm glad you identified this problem and it is so precise in fixing that problem. So I just want to commend you. And to end my comment, I should say, isn't that so? And who is opposed to it?
Thank you, Senator Kagan. I'm crossing the bill for her. Thank you so much.
Delegate Branch.
Thank you, Mr. Chairman. I'm just reading your bill. Oftentimes, African Americans are also overlooked for various reasons, and Native Americans as well, and others. But I notice this bill is particularly talking about immigrants. Is that right now, is something going on that where they're actually being biased against them in some way right now. Because like I said, African Americans have been fitting this particular piece of legislation for years. But so this only says that you cannot deny them. I mean, can that be other ethnic groups as well, or how does this work? Because it's a short bill.
It is short because what happens, Delegate, and thank you so much for your question, is that if you don't have a social security number, right, you cannot get the license. That's what happens. So that's why it's drafted in that manner. So if you are Native American, African American, most people have a social security number. This is for a group of people that do not have a social security number because the application for license requires that in order for it to be approved and processed. So for instance, you have an immigrant who can be, let's say they have an ITIN number, which is a number given by the federal government so that they're able to work and pay taxes, right? Some of them, not all, are actually getting their documentation. They can be married to a US citizen or they have a green card and they're waiting for their final paperwork, right? And they don't have the social security number. So they go through the nursing program, which is what happened to a young lady I helped. And then she completes the nursing program, but because she does not have a social security number, she cannot be given the license for nursing to become a nurse. So it's very prescriptive because it's for people that do not have a social security number.
Okay, yeah, well, the bill doesn't say that, but I was just curious why it was kind of worded that way, but I'm not going to belabor it.
Yeah.
I get it though. I do understand now, and I appreciate you
No,
explaining
my
it to
pleasure.
me because I was wondering why.
Of course.
Didn't mention any other ethnic groups. It's pretty specific, but I get it now. I do.
Yes, thank you. Of course.
Thank
Thank you
you.
so much for your question. I appreciate it.
My pleasure.
And Delegate Howard, I know you have your hands up. I do believe we have one more witness. If you don't mind waiting till this witness is just done, I don't want to miss him.
Sure.
Donald Graham.
Mr. Chairman, members of the committee, I'm Don Graham, Chairman of Graham Holdings Company and co-founder of a scholarship fund called the Dream.us. I live in Washington, D.C., but I've done business in Maryland all my life. I was publisher of the Washington Post for 21 years, and our company owns a Maryland auto dealership and the Clyde's Restaurant Group. I have a deep admiration for this body and this committee. 8 years ago, I co-founded a scholarship fund for undocumented immigrants. We've partnered with 70 colleges, including starting last fall, St. Mary's College of Maryland. We've enrolled over 7,000 students, and those who've enrolled in four-year colleges have a 79% graduation rate. They came here, these students, at an average age of 4. We've partnered since 2014 with Trinity Washington University, a women's college in Maryland that's long served Maryland students. 51 Maryland high school graduates have attended Trinity. I expect 90% will graduate. One testified today. Maryland has been generous to undocumented students. The state was among the first to give them in-state tuition at state universities and to give them the same state financial aid their high school classmates get. Every legislator should be thanked for that. I think that what the state was thinking was these students came here as children, giving them a chance for college would be good for them and good for us. The state will benefit for their labors and their ability. This is the logic of House Bill 533. Undocumented students are here in large numbers. As Delegate Peña-Melnick just said, they are graduating from college. You have a critical shortage of nurses and other healthcare workers in Maryland. Among our Dream.us students nationwide, more major in health careers than any other subject. So Maryland's in the odd position of encouraging these students to go to college where many study nursing. Then when they want to work here, the state hasn't yet taken the step of allowing them to take these licensure exams as 5 other states have. I hope Maryland will join them. I think this is a wonderful bill. I thank every member of the committee.
Thank you for your testimony, sir. We have questions, so, Delegate Howard.
Yeah, so it says in the fiscal note, this bill says, Delegate Peña-Melnick, says about the relevant, looking it up right now, here we go. It says the bill defines immigrant, registration of an immigrant meets the relevant educational training or professional requirements. We're talking about a very, very broad, I don't want to even say category, a very, very broad landscape of professional certifications and licensure. Who is going to decide what is relevant and what isn't relevant as far as the training is concerned when it comes to licensure?
As you know, the Department of Labor oversees about 25 boards and commissions,
Mhm.
I believe, in the state of Maryland. So each board has their own requirements and is the board who oversees those professional requirements, and you must meet it. This bill, delegate, does not change the requirement for that particular board, for that particular profession. It does not, you have to do it and get it on your own merits, complete the paperwork, the coursework. It doesn't change any of that at all. It only allows a person who does not have a social security number to be able to get the license if, in the judgment of that particular board, who have their own laws and rules and regulations, they have actually, adhered to it and complied to it. So the bill does
So
not
the
change
board, so the boards over at DLLR will decide what's relevant as far as
that. That
the
is
training.
correct, as they
Are
do
those,
every
are
day.
those individuals elected or appointed or hired, or where do they come from? What's their
So
background?
some of the board members are appointed by the governor. Some are appointed by the General Assembly. So some have executive directors that are higher and must be higher based on their resume, their education. So as you know, as legislators, we trust our boards and commissions, and they're professionals. They're often professionals themselves. Most of the boards are made out of that particular profession as well. So these are people that we trust, and especially to advise us in passing a lot of these bills.
Okay, so and they'll decide what the relevant course materials are as far as this person has done X, Y, because we know there's a lot of, I don't know, I didn't go to college. I went to Paris Island and then the Army. So electives, there's a lot of courses out there that are just sort of filler, if you will.
But the schools
as far as college
decide.
is concerned, as far as some of these other training is concerned, I'm sure. So these boards over at DLLR, they'll decide what the relevant material is and whether or not this person is. Now, once those people are appointed, what is our recall method if we're unhappy with some of the decisions of removing or adding criteria? What's the, how do we fire them? How do we hire them? How do we, let's say we get a bad egg in there on one of these boards. How do we remove that person? We can't. Once they're appointed, they're appointed.
Usually when there is a problem, first of all, this bill doesn't deal with the boards. It does not change the merits. For example, I'm a lawyer. I went to college.
You're right. This bill doesn't change the merits, but this bill gives those boards, because it says, speaks specifically to, in the fiscal note, relative educational training or professional requirements. And so what this also does is it defines immigrant or illegal immigrant, or however you want to put it, which is federal, says that in the fiscal note too. And then it flips, to me, I guess, on its head, individual meets the relevant educational training or professional requirements. So what this does is it puts the power in those boards' hands to define how little or how much those requirements should be.
But that is the law right now. This bill is not changing that.
I just want to make it clear that everybody, myself, doctors, nurses included, we have colleagues that will do nothing to weaken the standards for our practices. And I think these boards, they have the people that are appointed that are also colleagues, and they're all in their own individual practices and the subject matter experts. So to my knowledge, this bill does not lower the standards of acceptance for education and training. It merely
but it gives those boards the ability to do so.
Those boards have always had that ability. That was my point. The boards have had the ability now to determine your character, your fitness, and your training, and decide whether it's applicable and acceptable. This is just allowing them to say that you can apply. not be guaranteed approval.
That's
but
right.
apply without a social security number. That's my understanding of the bill.
So with,
Right, it is,
so
and
without the social
it is.
security number, thank you for your testimony, Mr. Chair.
It is. Well, you have to be approved based on the merits of your application, delegate. This bill does not change the requirement of the boards. Each board have their own rules. Each board have their own requirements of what it takes to be a nurse in Maryland, which is why sometimes when someone from Pennsylvania comes to Maryland, you know, and the coursework is not as stringent as the Maryland requirement, they're not able to get the license. Each board has their own rules, their own requirement. The bill does not change that requirement for any board whatsoever. It does not touch that. You still must comply with whatever the requirement of that board is, and each of them act independently.
I believe we have one more question. Delegate Adams.
Sure. Thank you, Mr. Chair. And yeah, so look, following up on what Delegate Howard was saying, that, you know, in DLLR, there's the MHIC, Maryland Home Improvement Commission. And so in that scenario, I'm trying to understand what that commission would be looking at. First off, they're going to have employees, so they're going to have a account set up with the comptroller and with the federal government to be able to actually do business. How does someone who has status like this actually get in front of a board or commission if they can't set these basic accounts up, or can they? Are they able to get insurance? Are they able to get workers' comp? Are they able to set up all the? It's not just the license; it's that they have to have a viable business. And I'm just there's more to it than just showing up at a commission and saying, "I know how to be a practitioner. I know how to be a contractor." I'm just trying to figure out what it is you're trying to fix, because licensing is just one part of the mix, right?
Licensing is one part of the mix. There are many people right now in the state of Maryland that have, for example, their ITIN holders, they have businesses, they have employees, they have insurance. So they're able to start their own business. This bill does not change that. This bill basically says that in the process of applying for your application to be considered, a lot of the boards and commissions have the requirement of a social security number.
Okay, so
And what the bill
says.
says.
Let me just follow up with one follow up.
Can I finish my thought though for a second?
Well, I think you're sharing testimony you've already given. I want to be brief. So let me just say, one of the problems with the MHIC that they deal with is people that show up at customers' homes, collect deposits, and then never show up to do the work. And so do you think a bill like this passing would cause there to be more of that sort of fraud on consumers in Maryland, or less?
You know what, and with all due respect to you, what you're implying is that people that are undocumented will commit fraud and will not do a good job. I know people that are hard worker, that are professionals, and they will do it. And to answer your question, no, this bill will not do that, because I trust the board, that the board will choose those that are professional, they have done the work and have, you know, meet the standards of that particular board, and will either get approved or denied on the merits.
So to be clear, I was probing and questioning. I wasn't making a statement. I thank you very much.
I understand. Thank you.
And I'll briefly just say that I know Delegate Adams for years, and I know he was not inferring that. He was most likely talking about the lack of oversight when you let the ubiquitousness of the licenses could create a lack of oversight and enforcement, not so much questioning the individuals or the non-documented workers' ethic. I do know him; he would not address it that way.
And I appreciate that. Sorry if it came out that way. Thank you.
Our agent of chaos, Delegate Fisher.
Thank you. Thank you. Thank you, Mr. Chairman. So my question is, once this individual who is not legally present in the United States gets this certification, that's an occupational license, certification or professional license and or certification, pursuant to what your bill intends to do, and then you have two people applying for a job, and one is an American citizen and one isn't. And what you're saying with your bill is that it's okay to deny the American citizen the job if he is also very qualified because you have this person who got into the country illegally and now has applied for the same job, and you're denying an American citizen the job?
If I may I answer?
Of course.
Okay, thank you. So what the bill does basically, it says on page 1, line 16, section 8506, it basically goes ahead, it goes and it describes the definition of who this bill would apply to, right? And we stated that it's for a non-citizen and someone who was born in another country and it's a resident of the United States.
Sure.
Then the second page basically says, a state occupational professional licensing board may not deny an occupational or professional license certification or registration to an immigrant if the individual otherwise meets all educational training or professional requirements for licensure, certification, or registration, and it ends there. The bill doesn't say, there's nowhere in this bill does it say that if there are two people applying for a job, that the American citizen shouldn't.
So Delegate Melnick, I've known you for a long time, and one thing I do know about you is you're very smart. And the practical effect of your bill, if it were to pass, would be that there would be literally hundreds of situations, if not thousands, in the state of Maryland, where you would, assuming that your bill passed, have individuals who would be applying for a job and they would be American citizens and they wouldn't be hired. And instead, they would be an individual who's not an American citizen here illegally, and they would be hired. And while your bill doesn't say that, and I fully acknowledge it, that is the practical effect of what the bill will do.
Well, if I may, with all due respect, and we know each other for a long time as well, and I appreciate you. Look, I would disagree with you respectfully. I think that it is up to the employer who he or she hires based on merits, whoever the best candidate is, and this bill does not change that.
No, and I understand. I hear what you're saying. I obviously don't think that that's going to happen. I mean, obviously, I'm coming from the position of the fact that if you have chronic high employment in a place like Baltimore City, and Baltimore City does have chronic high unemployment, it is indeed not true that there are so many jobs without people who want to fill them. And seeing that, I just read in the newspaper, and it wasn't Fox News, it was MSNBC, I think, where Joe Biden just put a whole bunch of, flew them into Baltimore or drove them into Baltimore, illegal immigrants into Baltimore. One would have to say to oneself, well, is it fair that these individuals who would be able to get these occupational licenses, when you have this unemployment in Baltimore, and these individuals in Baltimore would not be hired and would not be given preference over these folks who are not legally here?
Well, Delegate Fisher, if I may, there are 14 other states, including New Jersey, California, Illinois, I think even West Virginia, that are red and blue states, and the sky hasn't fallen. So I would say Maryland is not the first, not the second, not the third. We will probably be number 15, and it's being done and the sky hasn't fallen yet.
No, and I'm not saying that, and I don't want to belabor the point here, other than to say, I do believe that American citizenship matters and that we should be giving preferences to the American people to have the jobs that we create in America. And it's very simple. Thank you.
Oh, my pleasure. Thank you for your questions.
Since I'm
Thank
on.
you, no, guys. You guys are only here to respond to questions, guys. There was no other questions posed. That was barely a question. We will now move on to, I believe we're done with this bill. Again, thank you.
Cut sheets when I get them on.
Thank you so much, Mr. Chairman and committee. I appreciate you. You're muted, Mr. Chairman.
You're muted.
I'm glad I was muted then too. All right. Now we have two bills we're following. We're going to do these bills simultaneously. We have a bill, Delegate Valderrama 614 and Delegate Young 628. They're effectively doing the same thing. So we're going to be going forward, having both Delegate Valderrama, then Delegate Young, and then I will call a panel because their panels are similar. They have almost exactly the same people. So we will start with Delegate Valderrama, Bill 614.
Thank you, Mr. Chairman. Good afternoon, members of the Economic Matters Committee. Chris Valderrama here to present House Bill 614, Workers' Compensation, Medical Cannabis, Compensation and Benefits. This is not a new bill to the committee. This has been presented before. What this legislation clarifies is the ability of a workers' compensation claimant to be able to seek reimbursement after the fact for the cost of medical cannabis obtained by the recommendation of a treating physician through the process regulated by the Maryland Medical Cannabis Commission. So as you will recall, we, the great state of Maryland, legalized the use, the distribution, and the production of medical cannabis for certain medical conditions back, was it 8 years ago now, 2014. So currently, Maryland lists several diagnoses such as anorexia, glaucoma, chronic pain, seizures, PTSD, severe pain or nausea, and persistent muscle spasms as qualifying conditions. Cachexia, a weakness, or which is the wasting away brought on by severe illness, is also considered a qualifying condition in our state. Maryland is not alone in its treatment of medical cannabis as medicine. Currently, there are 36 states and the District of Columbia, Guam, Puerto Rico, the US Virgin Islands. They have all legalized medical cannabis. So in the workers' compensation setting, medical cannabis is most commonly used as an alternative to opioids. NSAIDs and muscle relaxers, especially for claimants who have a complicated condition and are unable or unwilling to use these drugs. As our understanding of the opioid crisis has developed over the past several years, many medical practitioners have looked to medical cannabis as a suitable substitute to opioids for the treatment of chronic pain. However, regarding workers' compensation coverage, there is a split among the states regarding whether to allow medical cannabis reimbursement as they would any other medical treatment arising out of a workplace illness or injury. So most states, including us, are silent on whether to allow workers' compensation claims for medical cannabis. So besides Maryland, there is Alaska, Arizona, Arkansas, California, Colorado, Delaware, Hawaii, Illinois, Louisiana, Mississippi, Michigan, Missouri, Montana, Nevada, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Dakota, Utah, Vermont, West Virginia, and our neighboring Virginia, who do not specifically forbid cannabis reimbursement. Though I will emphasize they do not specifically allow it either. So it goes both ways. I just wanted to emphasize that and point that out. There are 6 states though, Connecticut, Minnesota, New Hampshire, New Jersey, New Mexico, and New York, who do allow workers' compensation reimbursement for cannabis if deemed reasonable and necessary. Then another 6 states, Maine, Massachusetts, Florida, North Dakota, Ohio, and Washington expressly forbid the reimbursement for medical cannabis. So as the sponsor of this bill in the past year or two, now I lost track, in my view, what is most crucial for us to understand here is how the Maryland Workers' Compensation Commission currently, we'll just deal with Maryland right now. So how our commission deals or handles these cases. So with correspondence that we had requested and was provided, and thank you kindly, to our chairman of the Maryland Workers' Compensation Commission, the great Albee Carl Aumann, not sure if he's here with us today, he confirmed that since 2020, there have been 14 medical cannabis hearings heard by the commission. And in 2020, 6 cases were heard, with 3 allowing reimbursement and 3 denying coverage. And similarly, last year, the commission heard 8 cases involving medical cannabis and granted coverage in 6 and denied 2, only 2. So this legislation simply allows for the continuation of reimbursement for cannabis therapy. However, as a matter of fundamental fairness, we must allow all claimants, workers' comp claimants, equal access to this information about these limited claims and to this potential and to this option of treatment. Failing to publicize information about these successful claims and developing area of law is unfair to claimants who may have applied for coverage had they known it was even possible for them to obtain. So if you remember last year's hearing, there were 3 objections that I'd like to point out to this legislation by some of my colleagues, and 2 were from some insurance lobbyists, which was not unexpected. So some members of this esteemed committee, and quite fairly, inquired about how we will prevent the potential abuse of medical cannabis. If, for instance, a claimant is suspected of using his or her cannabis for recreational use. And the answer that I come up with is that because all workers' compensation treatments must be approved prior to coverage, meaning their dosages, depending on each claimant, they're all different, right? Let's say you get 3 days worth of medical cannabis, then you would use that for your therapy and there would be no abuse for recreational. That's one way to put it. I'm sure there will be objections to what I just stated. Having said that, moreover, there is a well-established appeal process where disagreements are settled between the claimant and the employer or insurer. If you ask the members of the Workers' Compensation Bar, who will later testify during this hearing, just how difficult it is to get legitimate workers' comp claims consistently paid out, and you will find that the workers' compensation system is far from a free-for-all. So it is an orderly, carefully controlled process meant to both treat injured workers and hold costs down for employers. So the first of the insurer's objections made last year involved the classification of medical cannabis as a legitimate medical treatment, absent approval from a federal agency like the FDA. If workers' compensation was a federal government function, then perhaps this argument would have merit. Though there's a very small federal workers' compensation program that covers civilian employees of the US government. So here we are speaking solely of the state of Maryland's workers' compensation system. So as such, workers' compensation in Maryland is subject only to this legislature's oversight. Regarding the medicinal benefits of medical cannabis, I believe that issue was settled 8 years ago, back in 2014, when we first legalized medical cannabis without approval by a federal agency. By law, the Maryland Medical Cannabis Commission has the sole authority to determine who is eligible for medical cannabis and for what conditions. And the final insurer's argument was slightly more complex, but equally, I'd say, incorrect. Here, the argument was raised that because the cannabis is still deemed illegal by the Federal Controlled Substance Act, an insurer, it was stated that an insurer who reimburses for cannabis would be breaking the federal aiding and abetting statute that was found at Title 18 USC Section 2 and could potentially be charged with a crime. As a practical matter, since the California cannabis law was first passed back in '96, there has, I emphasize, not one federal prosecution involving state medical cannabis statutes, including against workers compensation insurers, I should say. And moreover, the 3 levels of federal government, the executive, the judiciary, the legislature, and the courts, under multiple Democratic and Republican administrations, have all acted to prevent interference with the well-established state medical cannabis programs in the majority of the US. So while it's true that cannabis remains illegal under the Federal Controlled Substance Act, it is also true that the Department of Justice has prohibited prosecution of state programs. The US Congress has denied funding for such prosecutions, and the courts have upheld both of these actions to maintain the status of current state programs. So as a practical matter, the federal government has looked the other way regarding the federal illegality of cannabis and prosecution of an insurer for aiding and abetting in a federal crime is all but impossible at this time. Medical cannabis has helped countless patients, whether those patients seek help overcoming the side effects of chemo or seek help the avoiding use of opioids because of a previous addiction. And I had a I had a witness last year who will be before us again this afternoon who experienced that unfortunate episode in his life to addiction. This state has already recognized that medicinal properties of cannabis, workers' compensation claimants, they deserve access to these important alternative treatments at no cost to themselves, just as they currently receive for more traditional treatments. So for all these reasons and everything I have just mentioned, colleagues, I urge a favorable report. Mr. Chairman, there's a panel that is following me, which is Mr. Aaron Shepard, who was the witness that I just mentioned, and Mr. William Tilburg, Attorney James Lanier, and James McAllister, and finally Kevin Merrill.
I don't have the order. I'll go in the order on the sheet. I appreciate, and colleagues, I just want to remind you, we have a lot of hearings, a lot of witnesses. So as concise as we can make our statements, I would really appreciate it because we have a lot more to cover.
Be noted.
I wanted to, Delegate Young, I'm just getting some information that you put up that you no longer have a workers' comp. This is no longer a workers' comp bill.
Thank you, Mr. Chair. Actually, I amended the bill when I realized that Delegate Valderrama put her bill in again. My bill was comprehensive. It dealt with workers' comp as well as the ability of employers to screen medical cannabis candidates or terminate them. So when I read House Bill 614, I had the bill amended, and hopefully you have that amendment before you. It took all the workers' comp language out of my bill so that House Bill 628 just speaks to why there should be protections for medical cannabis users and why they should not be either screened for employment or terminated because of usage. So they are different now.
We did not get that amendment. Out of the 10 witnesses that Delegate Valderrama has, you have 8 of the same witnesses. So I'm assuming, and all the unfavorables are similar. So I'm not really sure how to go forward because these were very similar bills. Yours had a discrimination part in there. You have 2 witnesses that we will call at the end who may in fact differentiate your bill, if you don't mind. Would you, you've done a brief recitation of your bill.
Yes.
Would you like to go any further? Or would you
I
like
would, please.
Okay,
yes.
Please go ahead.
It was brought to my attention by a constituent who's in her mid-30s. She works for a major hospital in our state. She suffers from depression and anxiety. She had been prescribed Paxil, Prozac, Zoloft, had serious side effects to all of those until she got a prescription for medical cannabis. However, her employer does drug testing, which is not an indication of impairment, and you can't differentiate between medical and recreational. So this bill protects medical cannabis patients from employment discrimination if they're holding a written certification from a licensed medical provider who has been certified to prescribe. I think Delegate Valderrama mentioned the 36 states that recognize it. 14 of these states have enacted state-level protections for medical cannabis as a lawful medication. Treating medical cannabis patients differently from other patients is inherently discriminatory, and it produces a very harmful stigma, which creates both negative short and long-term effects. Despite the recognition of medical cannabis as a legitimate medical treatment, we're failing to protect our citizens who are forced to choose between their employment and their treatment. It should be subject to the same standards of impairment as prescription drug use and those who use alcohol. Impairment is the standard, not traces. Nothing in this bill prevents employers from adopting policies that prohibit an employee from performing work duties while impaired by medical cannabis. Because it's not legal under federal law, my other amendment, Amendment 2, it says that it doesn't apply to federal executive agencies covered by Executive Order 12564, and that's the Federal Drug-Free Workplace Program of 1986. I thought that was the best way to deal with the federal issue. At a time when we have workforce shortages, this is an important issue. We're losing a whole generation of people that don't want to take addictive opioids for pain, that want to deal with the depression and anxiety that so much of our population is dealing with today. And at a time that we're looking at legalizing recreational cannabis, we need to fix the barriers for the medical program first. Thank you for your time and attention.
Thank you. And I will say, because I know that we're calling these individuals for 2 minutes to testify on both bills. Yours has an added part, but I will say that from last time and discussions before is that negligent entrustment has always been the big issue here. And having individuals as an employer, if you own a construction shop or something of that nature, and it is very hard to tell marijuana, the only way you can do it is through, the hair follicle test or blood test, 30 days, putting these employers in a very difficult position to not be able to regulate who's using marijuana because you can't tell when they're using it. And again, and I'm not trying to do everyone's job. I just know that we're combining two bills, creating a limited amount of time for these people to explain their unfavorable arguments, but I will go in these orders to see if we can get it covered, okay? Thank you very much. My first witness on these bills is William Tilburg.
Good afternoon, Mr. Chair, members of the committee. Will Tilburg here on behalf of the Maryland Medical Cannabis Commission in support of House Bill 614 and House Bill 628 for the simple reason that the commission in the state, there's 150,000 Marylanders who are currently using medical cannabis through the state's authorized program. And these patients are not afforded the same legal protections as every other patient using medicine within the state. I'd like to start, Mr. Chair, where you wrapped up with the reference to testing. Drug testing for THC is a presence or not presence, whether something is detected. And due to changes in federal law, those tests are completely ineffective at determining whether someone has been using a THC product. In 2018, the federal government legalized hemp. So that is a product that contains low levels of THC. If you purchase a hemp-derived product that says CBD from any grocery store, convenience store, herbalist store, it likely contains THC and you would trigger a positive test. That is a product that is perfectly legal under federal law. So while the tests do not in any way and have never determined impairment, they're also not a good indication of whether someone is using a product that is actually federally illegal. To 628 and the employment discrimination, this is not a novel issue. 17 states and DC already have the same exact protections, including every single bordering state and jurisdiction to Maryland, DC, Delaware, Virginia, West Virginia, and Pennsylvania, additional neighboring states of New York, New Jersey, Connecticut, This is a very common protection. The sky does not fall. Businesses are able to continue to conduct business. Employees are reasonably protected. Both of these provisions have been implemented, 614, 628, in other jurisdictions, effectively protecting patients, but also ensuring businesses can continue with their business. Thank you,
very
Mr.
much,
Chair.
sir. Next witness we have is Kevin Miralat, excuse me.
Hi, Kevin Miralat. Thank you, Chairman Wilson, Delegate Valarama, and members of the Economic Matters Committee. My name is Kevin Miralat. I own a construction company with 45 years of experience as an MHIC contractor. I also hold an MBA and a Master of Science in Medical Cannabis Science from the University of Maryland. I'm testifying in favor of House Bill 614. The state of Maryland already recognizes cannabis as an essential medicine. Through the Compassionate Use Fund adopted by the General Assembly, you have shown that state agencies such as the Medicaid and the Veterans Administration can work together with the Medical Cannabis Commission in order to provide discounted medications for those groups. The ability for an injured worker to choose cannabinoid therapy over highly addictive drugs will be paramount in fighting our opioid epidemic. The CDC announced that we've now topped 100,000 annually as far as overdose deaths. When you look at those numbers, there's a 20% higher mortality rate for opioid deaths due to prescription opioids versus heroin. In my studies at the School of Pharmacy, we reviewed the negative effects of cannabis and found that it is indeed one of the least toxic drugs available. NIDA also states that no person has ever died from a cannabis overdose. Studies show an opioid sparing effect happens. 64% lower opioid use in patients treating pain that use medical cannabis, 25% lower annual mortality from opioids in states that have medical cannabis, better quality of life in patients suffering from chronic pain, fewer medication side effects. The federal government's inaction concerning cannabis has not and should not be the cause for the General Assembly not to act in the best interest of its constituents. In fact, the anti-commandeering clause protects.
We'll need you to wrap it up, sir.
Apologize. Yep, thank you.
Wrap it up. Okay, thank you very much. See no questions. Next witness we have is Aaron Shepard.
Good afternoon, and thank you for allowing me to testify today. You may recognize me from this same bill last session. In January of 2020, I took a very bad fall at work, which resulted in a shattered spine. After undergoing a very scary surgery and taking approximately 1,800 pharmaceuticals over the past 2 years, I am no longer on workers' compensation and am permanently disabled at the age of 47. Due to a previous opioid addiction, which stemmed from a prior surgery, I was strong enough to come out of this event pill-free. I do not think that would have been the case if it wasn't for my past near-death addiction. Though I still experience difficulties, cannabis has become my only medicine. Instead of multiple medications to treat my pain, muscle spasms, anxiety, and depression, all which are a result of my accident, I now use only a safe plant that Maryland has recognized as medicine since 2014. I am once again asking for a favorable report in hopes that injured workers not only have a safer alternative, but perhaps we can help put an end to this terrible opioid epidemic, which frequently begins with the prescribed pharmaceuticals. I'm certain that 1,800 pills over the past 2 years has caused considerable unknown damage. All I am asking is that you give the next injured worker a safer option if they choose not to want pharmaceuticals, and instead a safe plant that Maryland recognizes as medicine. Thank you once again for your time and consideration on House Bill 614.
Thank you, sir. Seeing no questions, James Lanier.
Good afternoon, Chairman Wilson and members of the Economic Matters Committee. My name is Jim Lanier, and I'm here on behalf of the Maryland Association for Justice, and we're requesting a favorable support for now just House Bill 614. Instead of repeating what everyone else does, it's the reason this bill is important to change the Maryland Workers' Comp Act is really on not just perception, but on legality. So we keep focusing on the commission, but many medical issues never even get to the commission because we can resolve them between the injured worker and the insurer and the self-employed insurer, whoever it might be, without needing the requirement of the commission. So for example, I have a case right now where both sets of doctors on both sides agree that medical marijuana is appropriate, but I still have to go to a commission hearing because the employer and the insurer are concerned that it's not legal. So then we have to file issues, we take up time in the commission, and these are not cases, as you will see, that have that much time. There's not that many of them. There's only 14, as Delegate Valderrama indicated. So the one thing, by amending this statute, it'll give the freedom, if you will, or the assurances to the employers and insurers that yes, Maryland has recognized this is specifically legal in the appropriate circumstances, because we have to go to the commission. The commission always has oversight over all medical issues. It is always the claimant's burden to prove that the necessity, the reasonableness, and the relationship of the medical treatment, including medical cannabis, is connected to the claim. So for example, even if the commission was to approve medical cannabis, if there's an issue about abuse, if there's an issue about overuse, or even something else more important or more effective comes by in the future, we can always go back to the commission and ask for another order to reassess whether or not it is still medically appropriate for this person to have medical cannabis. So because we have the protections of the commission at all stages, we're asking that the committee find favorable support for House Bill 614. Thank you very much.
Delegate Morgan, do you have a question? Do you want to wait till we have the rest of the favorables done?
Well, I wanted to ask Mr. Marlette a question. I don't know if that's possible. I'm sorry, Mr. Chairman. Thank you for calling on me. I'm not sure the format of your committee. Do you want to wait for the whole panel or you want to do it now?
Since you've started, we'll finish. Go ahead. Let him.
Thank you, Mr. Chairman. Mr. Marlette, I wanted to just ask a quick question. You were talking about recreation or workman's comp issues with medical cannabis. Can you tell the difference whether someone is smoking medical cannabis versus recreational cannabis?
Well, one, thank you, Delegate Morgan. One, I feel that the term recreational cannabis is an extreme overuse of a word, and it really shouldn't exist. The term should really just be regulated 21. Technically, there is no difference between cannabis that is being utilized for what we would call adult use versus a medical use. The cannabis is the same, but the use is quite different. There are, a person that, for instance, the person that testified that had a broken back, that is using cannabinoids in order to treat that severe pain. And the fact that there is an adult use side of it should not have any forbearance whatsoever on somebody not being able to utilize it for a medical event, for a medical reason. All humans were born with this wonderful thing called the endocannabinoid system. Okay. And simply all this is doing is using a cannabinoid that's purchased at a medical cannabis dispensary, which has already been approved by our General Assembly in order to treat an illness or in his case, severe pain using a plant that has never killed a single person versus using an opioid that kills 200 people a day. So that's kind of the difference between the two, is that the cannabis is the same.
Yeah, brief follow-up question, Mr. Chairman.
Sure.
You mentioned Cannabis 21. What about those people that are under the age of 21 that might be adults, even like if you're 18 and maybe still in high school, you're injured? What's your opinion of that? Should this be limited to them or? Mr. Millard?
Oh, I'm sorry. I didn't realize that was a question.
Oh, yeah.
I thought you had asked Mr. Chairman.
No, you mentioned Cannabis 21 and kind of drew the line there. I'm asking you a question as far as like, should it be limited to people only above the age of 21? What about those adults? They're under the age of 21, and even those are still in, let's say, high school.
Well, the differentiation there would be that a regulated system, you don't have to have a certifying provider in order to say that you can utilize the cannabis. On the Medical Cannabis Commission side, you in fact do have to have a certifying provider to authorize that use. And there is a clause under that for pediatric use. Whether or not a person happened to be a PD, I think that would be more of a if they fit under the medical cannabis clause and they have a certifying provider, then that age differentiation is not necessarily there.
Okay, I appreciate it. Thank you, Mr. Chairman.
Thank you, Delegate Howard.
Thank you, Mr. Chair. Mr. Marilat, you said there's no difference between recreational and medical use cannabis?
In that the cannabis itself is the same. The compounds are the same. Yes, sir.
Okay, so alleviate my concerns about human machine interfacing with medical and recreational use then, since there is no difference.
Well, you're trying to draw a line there that I'm saying there's not a difference between medical cannabis and adult use. The cannabis itself, the plant, the material, the compound is the same. So I know personally, all I can speak to is my business, and I have a construction business where people operate heavy equipment. They utilize machinery, and we have a strict no intoxication policy on the job site. However,
what about the carryover effects? I'm specifically citing the National Labs of Medicine on pilots, commercial pilots, the 24-hour and 48-hour carryover effects.
Well, if you look at the time, that it's called the half rate. So basically the time it takes for that cannabinoid or that drug to exit your body, it really depends on the route of administration. If a person inhaled cannabis, typically that inhaled cannabis has run its effect within an hour to 2 hours. If it's edible cannabis, then that effect could be longer, more 4 hours to 24 hours, which is why there's a medical benefit there. When you refer to a pilot, at that point in time, I would go back to the licensing and the ethics that the pilot has. You know, it's their job to exercise their proper sobriety, and if they're going to fly a plane, you know.
But there's no, but that's not what this bill speaks to. This bill speaks to medical marijuana and being covered on the job, and that being codified in Maryland state law. There are commercial pilots, there are recreational pilots, there are pilots for the Maryland State Police. So essentially they would have access to this. So I just wanted to get your opinion on that. And again, I mean, you talk about 2 hours, 4 hours. I'm looking at a National Laboratory of Medicine study right now, National Center for Biotechnology Information study right now, that talks about 48 hours after ingestion, smoking. And you just quoted 2. So I'm just trying to see how we square that.
Well, the study that I'm referring to is a study that was basically done on dronabinol, which is a marijuana, it's basically used for breast cancer and stuff like that. It's a synthetic cannabis pharmaceutical that has actually been
So it's different from the cannabis we're talking about here, which we've already established we can't differentiate from recreational use. So that study has no bearing on this whatsoever.
Well, if you are a commercial pilot, then I would suggest that you use your best judgment. And if there is a study that shows 24 hours or 48 hours, then that pilot should have to wait 48 hours after utilizing cannabis.
But I'm talking about any machine interface.
Well, and Delegate Howard,
it's a machine interface question.
I believe
you have people using heavy machinery. You have a sobriety policy. In the military, we called it 8 hours from bottle to throttle. I'm sure the chair is very aware of the safety briefings that we all got, those type of things. But, you know, we have legitimate, well-funded, well-crafted, blind studies from the United States government that speak otherwise to the testimony that's being given here today. So I wanted to get your opinion. I think we've got it. And,
can I ask
forward? Thank you very much.
What does it show for opioids?
At this point, gentlemen, again, we're not going to do this back and forth. I believe Delegate Howard brought up his valid point. I believe he gave a response. I think we do have to move on for the timeliness of the other bills we have to hear in respect of the others listening. The next witness on this will be James McAllister.
Mr. Chairman, can you hear me?
I can.
All right, certainly. Am I speaking to both bills or just one?
You're speaking to both bills, sir.
All right, certainly. Mr. Chairman, members of the committee, we're here. Jim McAllister, I'm a trial lawyer, Maryland Association for Justice. In the past, this bill has been opposed by people who questioned whether marijuana was an appropriate medical treatment. That ship has sailed. The legislature's already made that determination. Next, it was suggested that, oh my God, every single workers' compensation claimant who stubs his toe will go out and get a marijuana card, and these poor carriers will have to pay for it forever. Let me just tell you, workers' compensation is not health insurance. Every single prescription that one of my clients gets, be it for medical marijuana, be it for opioids, be it for aspirin, has to be submitted and approved by the workers' compensation carrier before the client gets the treatment, before the client gets the drugs, before the client gets the medical marijuana. And if the carrier says no, then we go to a hearing and a commissioner decides. And at that hearing, the employer submits a medical report from its expert, and I submit medical reports from my experts. So we have a commissioner that's looking at experts from both sides. And believe me, when I tell you that the notion that they approve or have to approve or are required to approve every single medical request, no matter how frivolous, is an absolute falsehood. The opposite is true. They fight us on everything that they can when they have a good faith reason to deny. How does this bill help workers with regard to the workplace? If you're working and your doctor thinks you need medicine, should you have to give up your job in order to take the medicine when there's no evidence that you're intoxicated? There are ways of screening people that have used drugs. They're called drug recognition experts. If these employees are taking cannabis, and that they should be required to disclose it to their employer so their employer can make sure that they're not intoxicated when they show up for work. Thank you.
Thank you. And next would be Stephanie Dorsum.
Good afternoon. Let me just find my paper. Here we go. I have submitted written testimony with links to the laws in the surrounding states, and they've been covered already. So I'm going to trust that's all been read, and I'm just going to summarize. In 2014, Maryland legalized medical cannabis. Unfortunately, unlike the laws in surrounding states, there are no employees protections for those of us who are legally using medical cannabis under Maryland law. While I could test positive for a plethora of opiates that I have been prescribed and have no concerns about keeping my job or applying for another job, I am not protected for using a safer medication with practically no side effects. Even being here and testifying realistically puts me at risk for my job that I use because I use medical cannabis before bed in order to be able to control my pain and be able to sleep. There are many like me who have been careful about discussing our own use of medical cannabis, knowing that it can put our jobs in danger, while also knowing not having access to medical cannabis could lead to medical disability. I want to continue to work as a pediatric physical therapist as long as my body will allow me, but I need medical cannabis before bed to allow me to sleep without the chronic full body pain that is a result of early onset arthritis due to Ehlers-Danlos, a genetic condition. I have never been impaired at work and never will be. In fact, I'm actually safer at work and driving because I'm better rested than I was before medical cannabis, because at that point I was only lucky to sleep for 2 hours and had a stomach ulcer due to the amount of ibuprofen and muscle relaxers I was taking. I would very quickly like to address the minors. My son is 16 and has been using low levels of cannabis since he was 13 for a chronic headache. He has a 4.0 joint GPA and is a number 3 in his class of over 559 students. As we both like to say, we are better employee and student, not despite medical cannabis, but because of medical cannabis. I'm asking for a favorable report on House Bill 628.
Thank you. Our last favor will be Arian Carver.
Thank you, Chairman Wilson, Vice Chair Crosby, and members of the committee. My name is Ariane Carver, and I'm a student attorney at the University of Maryland Carey School of Law's Public Health Clinic. The committee should vote favorably on House Bill 628 with sponsors' amendments for 3 reasons. 1, it reinforces the General Assembly's recognition of medical cannabis as a legitimate medical treatment. 2, it recognizes the public health impacts of discrimination against medical cannabis patients And 3, it accommodates employers' needs to provide a safe workplace and comply with federal law. When the General Assembly legalized medical cannabis in 2014, it determined that medical cannabis is a valid medical treatment, and medical cannabis patients should not be treated any differently from patients who use other legal and legitimate medication. By adopting House Bill 628, Maryland will join many states that protect medical cannabis patients from employment discrimination. Second, treating medical cannabis patients differently from other patients is inherently discriminatory, which stigmatizes medical cannabis. Research shows that the stigmatization of medical cannabis leads patients to delay care or not seek care. If medical cannabis patients fear reprisal from their employers for their outside use, they may end up having to choose between their employment or their medication. In turn, lack of employment can result in poor health outcomes such as high blood pressure, stroke, and heart disease. Finally, this bill preserves an employer's right to regulate workplace safety. Nothing in this bill permits employees to perform their duties while impaired by medical cannabis. Additionally, the bill does not require employers to provide protections for medical cannabis patients if doing so will violate federal law or cause the employer to risk their federal funding sources or licensing. For these reasons, I urge a favorable report on House Bill 628 with sponsors' amendments. Thank you.
Thank you very much and good job. All right, now we go to the unfavorables for these two bills. Julie Murray.
Thank you very much. Chairman, can you hear me okay?
Yes, I can.
Great, thank you so much. Thanks to the members of the committee for taking the time to hear our testimony on this bill. My name is Julie Murray, and I am the co-chair of the Maryland Workers' Compensation Subcommittee for the Maryland Defense Council. I'm going to primarily speak to House Bill 614, since it's my understanding that there are now amendments being proposed to 628. On behalf of the Maryland Defense Council, our position on this bill is that it still poses problems for employers and insurers in our workers' compensation. Some of my colleagues are going to speak in more detail as to some of the legal issues, but I would like to address the specific problems that we have that are still not addressed or remedied since the bill was first introduced last year with regard to the metrics on the certification. There is still not a lot of quantifying criteria in the bill that addresses how we would define impairment, how we would define a certifying provider, and how we would regulate the actual amount and specific types of medical cannabis that are being prescribed to employees. We think that without clarification on these metrics, the bill poses a problem and can create a slippery slope for employers and insurers. The other issue that we have with the bill as drafted is that we do still believe it's too early for the passage of this bill. The legalization of medical marijuana at the federal level still has not been addressed. It's still a problem that continues to persist. It's still something that our employers and insurers are very concerned about, and it's not something that has been eradicated by the revisions to this bill. As a result, on behalf of the Maryland Defense Council, we would ask for an unfavorable report. Thank you very much.
Thank you. Next would be Michael Daly.
Thank you, Chairman Wilson and members of Economic Matters. My name is Michael Daly. I am a co-chair of the Maryland Defense Council Legislative Committee. We're asking for an unfavorable report, and as Ms. Murray pointed out, we are each going to try to discuss certain specific areas that we believe could potentially adversely impact our members' client base. Interstate commerce is a huge concern by the Maryland Defense Council with this bill and with 628 as well as worded. For example, many of our members' clients are interstate trucking companies. As they pass through state by state, depending upon what that particular state's law is, including Maryland's, this certainly raises some level of concern if they're testing positive for cannabis. The bills, and I think the concern we have about some of the favorable arguments is that, well, this covers those circumstances. Employers have the right to have rules and regulations that prevent that. The problem is, what is the standard in terms of impairment with cannabis? There is no standardized, accepted level of impairment. And our clients just don't have the ability to measure that. They're just simply something not available for them to do. Finally, Mr. McAllister said something about the insurers must authorize the fills before they're made. That is not accurate. In fact, the opposite is true. Typically, injured workers for any kind of prescription medication simply can get it filled. There are companies that do that without authorizations from the insurance carriers. For these reasons, we're asking for an unfavorable report. Thank you for your consideration.
Thank you. Next is Robert Erlinson.
Thank you, Mr. Chairman. Can you hear me?
Yes, sir.
Okay, thank you. First of all, I want to adopt the arguments raised by the two earlier opponents of the bill. I'm speaking on behalf of Maryland Self-Insurers and Employers Compensation Association. The proponents of the bill have spoken about the individual rights of the individuals who obtain certifications. I'd like to address the rights of the co-workers and the employer that hires those co-workers. If you'll look at the statistics over the last several years, you will see that workers' compensation claims have been steadily dropping. There are a number of reasons for that, but one of the reasons certainly is the adoption of drug-free workplaces by employers. This has had a significant, I believe, impact concerning the number of claims, but most importantly, the severity of those claims. With the adoption of this statute, this puts the employer in a position whereby they're adopting policies to prevent people from taking drugs, and yet employees are coming in with certificates saying, "Please, I'm free to do that." And I think that puts employers in a terrible situation. So for that reason, and the reason stated previously, we would be asking for an unfavorable report. Thank you, Mr. Chairman.
Thank you. Last one to testify on this bill is Bob Enton. I've seen him try and jump in a multitude of times. In the meantime, Delegate Charkoudian, you have a question?
Thank you, Mr. Chair.
Thank you very much, Mr. Chairman. Sorry, Mr. Chairman, can you hear me now?
Yes, go ahead. Hold on, Lord. Go ahead, sir.
Thank you, Mr. Chairman, members of the committee, Robert Enton. Speaking today on behalf of the American Property Casualty Insurers Association in opposition to the bill. My testimony is pretty simple. I don't think that it's appropriate for the state to pass a law which mandates that someone violate federal law. It is a violation of federal law to facilitate the sale or distribution of cannabis. It's that simple. And I appreciate what the sponsor said. Well, practically speaking, no one's been charged. But I just ask you to put yourself in the place of carriers. And would you want to not have the choice to not violate federal law? It just seems to us that, there are bills pending in Congress that would legalize cannabis. When that becomes legal, fine. This argument is gone, it's out the window. But until then, it seems to me it should be up to the individuals. Cannabis growers, cannabis dispensaries today, they've made the decision that regardless of the federal law, they're going to participate in this marketplace. Don't believe we should be forcing companies to go ahead and violate the federal law and participate in this market. The only people entities that would be mandated to supply this would be the insurance carriers. And we don't think that's appropriate either, Mr. Chairman. For those reasons, we are opposed to the legislation. Thank you.
Thank you, Mr. Enton, for what we heard. Delegate Charkoudian, you have a question.
Thank you, Mr. Chair. I think the question is for the Defense Council, either one. I'm trying to figure out what the current policies are as it relates to impairment when someone is using an opioid to deal with a pain or whatever to deal with whatever the issue is that's tied to the workers' comp claim.
I'll be happy to start, Delegate. Many of our members, clients have drug testing or drug testing centers that they partner with. So if in the event of any kind of work-related accident, the employees are required to go and provide a sample to be tested and determine whether or not they were impaired by an opioid.
Okay, and so could the same system be used if they were using medical cannabis?
Well, that's a great question. I think the problem is, to my knowledge, there is no standardized testing capability to determine what is deemed impaired on a regular basis if somebody's using medical cannabis.
Okay, I'm not sure if that's the case or not, but I'll look into that. I guess the last thing I'll just say is I think that as we look at death rates soaring from opioids, that it's incumbent on us to push a little bit harder to find solutions that let people respond to their pain without having to end up addicted and ultimately dead from overdose. And I'll just leave that with, isn't that so? Thank you, Mr. Chair.
Thank you. All right, see no more questions on those two bills. We'll move on to the next bill, Delegate Hill.
Thanks. Good afternoon, Mr. Chairman. It's my first time appearing before you in your new role, and I congratulate you. It's good to be here this afternoon.
Thank you.
I am, and good afternoon, Mr. Vice Chairman, first time presenting in front of you as well in this role, and to the committee. So for the record, I'm Terry Hill, and I'm presenting to you HB 439, Workers' Compensation Occupational Disease Presumption for 911 Specialists. This bill is the work product of the Commission to Advance Next Generation 911 across Maryland, which over the last 3 years has done a terrific job of really bringing us into the present day and making sure that we have a 911 emergency system that is ready for the challenges of the day. I just joined the commission in the last year, but give all credit to Senator Kagan, Senator Riley, now Senator Jackson, and Delegate Krebs for all the work that they've done, along with the various stakeholders from across the state who've worked really hard. So what this bill does is it gives a presumption for 911 workers, and that means the answering point workers, the public service access point folks, the people we call the 911 operators, for post-traumatic stress disorder, that it is a job-related injury. And it does so for a very good reason, which is that this is an incredibly stressful job. And it is not unusual at all for people in this job to experience some type of stress, whether it's depression, anxiety, PTSD, or what have you. And what we're doing right now is we're not allowing them, we're requiring them to prove that that kind of injury was sustained on the job. And there are kind of three reasons that I think we've done this. Two I've listed in my written testimony. One is that we have this belief that stresses that are recognized as coming with the job are easily managed by true professionals. So that if a 911 operator, PSAP personnel are experiencing these, then we're thinking, well, maybe they're just not cut out for it and they need to go on to another job. But we're not thinking that maybe it's the job that's causing the PTSD. Secondly, and this is what we particularly try and address with this legislation, we believe that to have a stress related to the job, you actually have to witness something that's emotionally distressing, or witness something that is traumatic visually. We don't always appreciate that sometimes what you hear can be as, if not more, stressful or emotionally detrimental as what you can see, particularly when you don't get closure, particularly when your job is to make things well and keep things going until the emergency personnel can arrive to take care of the situation in person. And so oftentimes you're not going to be able to do that, right? But I think there's also a third reason, and that is that we readily recognize physical injury, and that people can be lifting too much and throw their back out or whatever, but we have a really hard time recognizing emotional, psychological injury as readily. So as a result, we have up to 18 to 25% of folks who are documented in this profession with PTSD that we are requiring go through incredible loops to prove that it was the stress of the job. I would ask you, in addition to reading my testimony and looking at the links that I provided in my written testimony, that you pay particular attention to the testimony of those witnesses who are giving you firsthand what this job is like. So under this bill, the PSAT professionals would still have to prove job-related causality to receive workers' compensation benefits for other health issues, like, even though we know they can be related, like hypertension, diabetes, heart disease. But for this particular diagnosis, PTSD, this would allow a presumption that it is related to their job, and so they can get the workers' compensation coverage that they need. And again, remember, and you guys know this, workers' compensation doesn't mean that it has to be a permanent disability. It doesn't mean it can be temporary, it can be short-term, it can be long-term. But we want to make sure that they get the care that they need and it's appropriately covered, as it should be, through the Workers' Compensation Fund. Thank you. And I ask for a favorable report.
Thank you, Delegate Hill. Susan Greentree?
Yes. Okay. 1 second here. Look at that. Okay. I'm Susan Greentree, and I'm speaking in favor of House Bill 439. I worked for Anne Arundel County 911 for over 35 years. When you dial 911, the person you talk to who's going to help you and get emergency services en route is me. Hopefully for you, these are rare events. The 911 specialist is hearing and triaging these events every day for years. Sample of calls: a mother came home, found her teenage daughter hanging. She was hysterical. Tried to coach her to cut her down so we could begin CPR. She was unable to get her down. I told her to grab her legs, hold her up. As minutes passed, the mother thought she could no longer hold her. Yes, she can. You're a mom and you can do it. When the medics arrived, the team was in cardiac arrest. They transported her to a Baltimore trauma center. After months in rehabilitation, the girl made a full recovery, and I know that I helped save that child's life. A woman who lived alone was having an asthma attack. I got medics en route and stayed on the phone with her, assuring her help was coming. Her breathing getting increasingly labored and stopped. Listened to her take her last breath before help arrived. They were unable to revive her. As a supervisor, I was monitoring a call taker handling a violent call and notifying the fire department. A 15-year-old boy had sent his sister next door and was beating his mother with a bat and yelling for her to die. Don't get up or I'll hit you again. And then we heard him hit her again. All I could think of was, could I love my children as much as I do, and one day would they try to beat me to death? The countless calls over years of violence, tragedy, crimes, medical emergencies, and overdoses, listening to people's lives shattered. In a 911 center, you keep going. Each call ends, and regardless of what it was, when the phone rings, you answer again. It changes who you are, how you think, and what you fear, and it breaks you down. It is an emotional career to be so up close and personal with humanity and the worst in the days in people's lives. I loved my job, but I know how the scars were left.
Thank you, and thank you for everything you do. It's an incredibly important job. Next, we have Robert Phillips.
Yes, sir, Mr. Chairman. Thank you very much. I sit here as my name is Robert Phillips. I am the chairman of the MSFA Legislative Committee. And the MSFA does ask for a favorable vote on this bill. We feel that the 911 specialists, they're the first link in the first responder system. Just like was just said by Ms. Greentree, they get the phone calls. and they have to listen to them, and they have to take care of them. I'm going to relate something. I know firsthand what the dispatchers go through. My wife was a dispatcher for 17 years, and I saw what it did to her. It got to the point she came home and sat in the middle of the floor and cried. She couldn't deal with it anymore. I'm sorry, I'm a little emotional about it, but those dispatchers take these calls of every size, shape, and description, and they pass them off. And then they have to sit there and wonder what happens next. Ms. Greentree talked about the calls she took. I know the ones my wife took, where she'd sit up in bed in the middle of the night and cry, scream. Then she had to go sit before a workman's compensation hearing and try to describe why her job did this to her. I will say, thank God, she won her case, the first one in the state of Maryland. I hope another dispatcher never goes through that. We ask for a favorable report, and that will be all, sir.
I just want to get on that sooner than later.
Thank you, Mr. Phillips, and please, from the bottom of our hearts, thank your wife. Please tell her that. I can't imagine all the calls she took over 17 years. Next, we have Sharif Thomas.
My apologies. Thank you, Mr. Chairman, and you go with the board. My name is Sharif Thomas. I am a 911 specialist for Montgomery County. I've been here 3.5 years. One of the things a lot of people don't realize is that every day you turn on the news, you watch events, terrible events happening, and everyone does not understand the fact that as 911 specialists, those events go through us. We pick up the phone from the people that are calling, crying, screaming. We try to decipher what's going on, and we try to get help out there to them. It's very emotionally taxing. It's mentally taxing. It does a lot to us that a lot of us and these specialists, a lot of us as specialists do not do much to tell everybody about. A couple of the calls that I've taken, especially one just recently, I heard a man have trouble breathing. And I mean, it was terrible trouble breathing. And I listened to this man die on the phone. And there's nothing that I could do about it, send him help. I sat on the phone for 10, 15 minutes trying to get help to this man and tell responders that they're outside the door to break the door down to get to this man and, do the best that I could. I've heard moms scream for their children as they're dying. I've heard victims try to get away. You hear them fight and negative things happen to them. And we're hoping for a favorable bill for House Bill 439 because I've only been here 3.5 years, and a lot of my coworkers who have been here 15, 20 years have heard way worse than what I've heard, and it has affected them differently than how it's affected me. So we're just hoping for a favorable vote in support of this bill, House Bill 439.
Thank you, sir. Next, we have Matt Pavola.
Hello, good afternoon, Delegate Crosby. Thank you for permitting me to speak. I am with the Maryland Association of Justice on the Legislative Committee, actually the Subcommittee on Workers' Compensation Bills. We favor a passage of 439 because of its heroic implications. We just heard from Greentree, Phillips, and Sharif that gave us just a tiny glimpse of these heroes. And Delegate Hill did such an excellent job of giving the overall package. So let me see if I can go in from a practitioner's viewpoint to give some insight that others haven't. I've been practicing workers' comp for 40 years, representing claimants. I would just want everyone on this committee to know that this will have minimal impact. First of all, it's an occupational disease. Those are very difficult to win, first of all, unlike an accidental injury. Secondly, it's limited only to permanent PTSD. That's the only condition the bill specifically addresses. So now you've reduced it further. Thirdly, the practitioners who are on this group will tell you we rarely get clients who are 911 specialists. Lastly, of course, it requires a doctor's to either a psychologist or a psychiatrist to support the treatment. Finally, although it is a presumption, the defense can rebut this. They'll be able to put on evidence that says, no, 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 this is from something else, or our psychologist disagrees. So for all of these reasons, from a practical viewpoint, it will have minimal fiscal impact. We urge this committee to pass 439. Thank you very much.
Thank you, sir. Next, we'll move to the unfavorables. Carmen D'Alessandro.
Thank you, Vice Chair Crosby, members of the committee. My name is Carmine D'Alessandro. I am Chief Legal Officer for Chesapeake Employers Insurance Company. I also serve as president of the Injured Workers Insurance Fund. Chesapeake has about 20% of Maryland's insured workers' compensation market, including 9 counties and approximately 130 municipalities. And for the state of Maryland, IWIF represents the state in all their workers' compensation matters. And I'm here to respectfully oppose House Bill 439. First, post-traumatic stress disorder is already covered in workers' compensation law through case law, and I know there'll be other people speaking to that, Vice Chair Crosby, so I will pass the baton on that point. I would state that in the last 5 years, between Chesapeake and IWIF, we've accepted 339 claims involving post-traumatic stress. In fact, I've heard nothing today from the examples given, a claim that we would not accept. Usually in a presumption case, the reason we give presumptions is because it's a difficult evidentiary issue. Lung cancer. Did the firefighter's lung cancer come from cigarette smoke, or did it come from fighting fires? It's difficult for the injured worker to prove, so we give them a head start with a presumption. Post-traumatic stress is just that. There is a traumatic event that you can pinpoint whether it's work-related or not work-related. As such, you can see how many we've accepted. You don't need a presumption for that evidentiary standard. Lastly, as anyone who's been on this committee for a while knows, that presumptions never stop with the original bill. They proliferate. In fact, even in the testimony, we've already mentioned anxiety and depression, and we haven't even gotten through the post-traumatic stress bill. And you can be sure that more and more employees will try to add this presumption. And in my written testimony, you can see the fiscal impact that proliferation would occur. For those reasons, Chesapeake and I would respectfully ask for an unfavorable report. Thank you, sir.
Thank you. Julie Murray.
Thank you very much, members of the committee. This is Julie Murray again on behalf of the Maryland Defense Council. I'm going to speak today to one of the points that Mr. D'Alessandro alluded to in his testimony, which is the fact that our base does believe that this bill, this presumption bill, is unnecessary. These claims for PTSD in the situation involving a 911 specialist are already permissible and already can be compensable under the case law in Maryland. Maryland has 2 cases specifically that deal with PTSD. The first is a case called Belcher versus T. Rowe Price. And the second is Means versus Baltimore County. In both of those situations, a injured worker filed a claim for post-traumatic stress, and the Maryland courts explained that it can be compensable so long as the injured worker can prove, the claimant can prove, that it arose out of and in the course of their employment, and that it was due to the nature of their employment. From the testimony that we've heard here today, there isn't anything in that testimony indicating that a presumption would change their ability to make a case under Maryland law. It doesn't change those requirements. It doesn't add anything to them. It's a bill trying to address a problem that does not exist. There is already an avenue for people who are diagnosed with PTSD as a result of this job to pursue a claim with the Maryland Workers' Compensation Commission. And there is already framework in existence under our case law. It's well-established case law, and that framework is there to permit those claimants to pursue a claim under the Act. For those reasons, we do think the bill's unnecessary, and we would respectfully ask for an unfavorable report. Thank you very much.
Delegate Mouse, did you have a question?
Once, if now's the time, but I can wait if you.
Oh, go ahead.
Yeah, I just for actually the questions for Chief Phillips. Chief, he's looking. Chief Phillips. So the testimony was that the bill's in search of a problem that doesn't exist. Would you like to comment on that?
Thank you. I can only speak from the experience that I went through with my wife it was quite a long time, and I'm sure there's a process, and I'm glad there is a process. I don't want that taken wrong. But for the person that is suffering from PTSD, every time that we had to go in for a hearing, my wife was asked to relive what happened. It wasn't like a broken bone that you can take a picture of. You can't see this injury. And it's additive. It starts small and builds and builds and builds. And at some point in time, it's more than can be dealt with. These dispatchers are professionals, take a great pride in what they do. And it's hard for them to believe that they can't continue taking care of people. And it's hard for them to express that. I've seen this firsthand. It did not happen to me. I've got 43 years in the fire service. She had 17 years. She was the voice on the other end of the black box. And she proved her case. And I'm not saying it can't be proven. I agree that it can. But when asked, and I think the standard at the time was you had to have 3 incidents that you could document. She sat there and listed off 27. And she had to relive each one of those. She knew in her mind, clear as a bell, when it came in, who it was, what happened. And that, I think, is the difficult part with this. And I really believe that presumptive, I think one of the other people just said using presumptive gives you a head start. And I think that's a good thing. And I'm not against having rebuttal. If someone comes back and asks questions, I don't have a problem with that. But it's difficult at best for these people to just start down the path of recovery. But the process, not like a broken bone, not like a slip, trip, and fall, the process is also in and of itself damaging and very difficult to deal with. I don't know if that answers your question, Delegate Motz, but thank you for asking.
It does. Thank you.
Can I add something or?
No, next up we have Michael Daly.
Thank you, Vice Chairman Crosby. I want to be brief and go right to some of the things that were raised. And again, I'm Mike Daly with Maryland Defense Council. Starting with number 1. The allegation that these 9503, including post-traumatic stress disorder claims, are rebuttable. There is no rebuttable provision within 9503. This has been talked about in the years that I've been before you all, and it doesn't exist. The practicality is, those of us that have practiced before the Workers' Comp Commission know this. The 9503 presumptions are truly irrebuttable. And to say that this would eliminate the need for somebody to come in and have to testify before the commission is not accurate as well. Even in the 9503s that exists now, the injured worker still comes in. The employer should have an opportunity to ask questions regarding what the claim is, the medical basis for it. And finally, as Ms. Murray pointed out, the Court of Appeals has already made it very clear 9503 cases that are not under 9503 can still be brought before the commission very easily. We all defend cases similar to this and have over the years. Most of them are found to be compensable. All of those under the facts that were submitted today and the favorables certainly would be found compensable. This simply is not a problem that exists. We're asking for an unfavorable report, and thank you for your consideration.
Mr. Daly, I have a question.
Yes.
How many do police officers have the rebuttable presumption for post-traumatic stress?
No.
What about firemen?
No.
What about correctional officers?
No.
Does anyone have this?
bill, Chairman.
Thank you. Are there, I see no further questions. We'll go on to Ashley Smith.
Thank you, Mr. Chairman. Can you hear me?
Yes.
Thank you. My name is Ashley Smith. I've been practicing in the workers' compensation community as a defense attorney for about 10 years. I'm speaking on behalf of the Maryland Defense Council. The points I've been asked to raise before you today specifically go to the drafting of the bill and the practical issues that those raise in terms of practice and the perhaps unintended consequences. The way this bill is drafted, it is grossly overbroad and it is very problematic. And I'd like to point out the 4 ways that it's a problem. First is that there is no causation requirement required from a medical provider. This means that an injured worker simply has to be diagnosed with PTSD in order to get benefits. There is no requirement that the trigger for that PTSD be in any way related to their employment. I would point out that other aspects of 9-503, which receive a presumption, are areas of medicine where finding the true cause of those conditions is somewhat murky. What causes lung cancer? What causes hypertension? That can be more difficult to determine. But the cause of PTSD, we know that because PTSD is a unique condition that is inexorably intertwined with a triggering event. So the bill should be amended to require a medical provider or psychiatrist to specify that this is the result of a work-related issue and not the result of prior sexual abuse or domestic violence or some kind of near-death experience while you're on vacation. I would also point out that this bill does not have any time limits or length of service requirements. Under the bill as written, someone could work for 60 days as a 911 operator, develop PTSD 15 years later from a motor vehicle accident, and still be eligible for benefits. Finally, this one doesn't require the following of the DSM-5, which is the most current diagnostic statistical criteria manual, and specifically addresses secondhand exposure trauma like this. And for that reason, we would request an unfavorable report. Thank you.
Quinn, you have a question?
Yes, Mr. Chair. Just a question, I guess, and I think probably Ms. Smith could answer for me. You made me think of something when you asked the question of Mr. Daly about presumption for firemen, police, and other types of occupations. Do we have some data on the number of police, firemen compared to 911 operators who make these sort of claims? Because I'm hearing that their cases would be no problem, but do we know how many have brought them up? How many they win compared to police and fire fighters?
Thank you, Delegate Queen. I don't have the answer to that in terms of specific information, but I can tell you that I have personally handled multiple PTSD claims for almost all variety of public safety workers, from correctional officers, firefighters, and police officers. I have never successfully defended against any of them. They almost always go forward and receive benefits, just like the case of Chief Philip's wife. They are usually almost always able to meet the medical and legal requirements for such a claim without a presumption.
Okay, but it would be good to know how many 911 folks are bringing them up, because until today, I never thought about them getting that sort of focus as I would a firefighter or a policeman. So I'm thinking, are we just, not considering them because we don't think that it's stressful to hear something? Maybe you didn't see it, physically. So it's a little different, maybe.
Delegate Adams.
Thank you, Mr. Chair. My colleague, Johnny, called me a minute ago. I just came in from another bill hearing, but I did want to acknowledge, Bob Phillips, who Johnny and I know is a good friend and volunteer here in Dorchester County. And I did hear your testimony, Bob. Thank you, Mr. Chairman, for the courtesy to share that. So Mr. Phillips heard me.
I believe next we have Brianna January.
Good afternoon. Thank you, esteemed committee members. My name is Brianna January, and I am representing the Maryland Association of Counties, also known as MACO, here to testify in respectful opposition of HB 439. MACO appreciates the concern of the bill sponsor for our 911 call takers, and counties surely share similar concerns for their mental health and well-being. And counties seek to take the best care of our call center staff. And thank you to the folks who serve in this capacity who have testified before me. However, counties do have several issues with the bill, and many of our concerns have been raised, but there are a few points that I'd like to make. Counties share Mr. D'Alessandro's concerns specifically with the precedent set by HB 439 in stipulating mental health diagnoses as presumed occupational diseases and the potential future implications for doing so. We also share Ms. Smith's concerns about the wide-reaching applicability of the bill as drafted. And furthermore, counties are concerned with staffing issues that could be caused by HB 439. We would likely need to hire additional staff and incur additional personnel costs to cover the absence of claimants, for example, who would be eligible for medical leave under the bill. To be clear, 911 call center employees provide critical emergency services for our communities 24/7. But the reality, committee, is that with more staff potentially seeking leave under the bill, communities may experience longer wait times for emergency intake and response. And that is a situation surely that no one wants for our shared constituents. So for these reasons, MACO does urge an unfavorable report from the committee. Thank you.
Seeing no questions, our last witness is Robert Erdlinson.
Okay. Thank you, Mr. Chairman. First of all, I'd like to just answer, at least provide a partial answer to Delegate Quain's question. Post-traumatic stress disorder is seen all the time in cases usually involving individuals who themselves have sustained physical injuries. And therefore, they're put in situations where they're in a wheelchair or have lost a limb or something like that. And so post-traumatic stress disorder, that is dealt with quite often at the Workers' Compensation Commission. With respect to the claims in question, I'd like to, first of all, adopt the arguments previously raised by prior opponents, but also I want to emphasize the point made by Mr. D'Alessandro in that there are a whole bunch of folks in this state, particularly first responders, who have stressful jobs. In fact, I would say that there are people who were not first responders, they have stressful jobs too. And so I'm concerned that if we start down this road of adopting post-traumatic stress disorder for these particular individuals, you are going to be seeing a long line of people starting at your committee room and going out right out to Route 50, who are going to be making the same contention. Gee whiz, we have stressful jobs. We should be entitled to a presumption. I would just ask the committee members, how frequently do you see, and I would suggest every year, somebody comes down to the legislature and says, I need a presumption in my favor for X benefits every year. So I would respectfully suggest that, and when I say this, I'm not in any way deprecating the stress that experienced by 911 responders. You're going to be opening the floodgates of potential recipients of benefits if this particular statute is adopted. So we would ask for an unfavorable report.
Thank you. And I have one last question, Delegate Harrison.
I changed my mind. Thank you very much.
Okay, thank you very much. Okay, that ends this hearing. Now we're on to Delegate Valderrama for her brief recitation of her bill, House Bill 501.
Yes, sir, Mr. Chairman. I will keep that in mind. Thank you. Members, again, here to present, Chris Valderrama here, to present House Bill 501, entitled Labor and Employment Workers' Compensation Claims Fees for Legal Services. A workers' compensation claimant in Maryland right now may be entitled to a wide range of benefits, ranging from lost wages, medical expenses, vocational rehab, to disability and even death benefits. Many, though certainly not all claimants, prefer to be represented by an attorney because workers' comp cases are quite difficult and very complex. So under current law, a claimant will not receive attorney's fees unless something more than medical expenses are at issue. If the only issue for a hearing is approval of medical treatment or the payment of medical bills, attorneys who spend time and money preparing for and attending these medical only hearings cannot be paid and their expenses cannot be reimbursed. So the legislation I'm presenting to you this afternoon seeks to level the playing field between an injured employee and more financially able employers and their insurers. So employers and insurers always attend hearings, including those where only medical expenses are at issue. And sometimes they unfairly use their knowledge of the system against employees who self-represent. So by allowing attorney's fees and medical only cases limited to $2,000 paid for by the insurer, we will help ensure that all workers' comp claimants receive the benefits to which they are entitled to under the law. And finally, this legislation gives the Workers' Compensation Commissioner the discretion to grant attorney's fees subject to the $2,000 cap. So for these brief reasons, I cut out some. So if the panel behind me would like to fill in, they're totally entitled to do so. I urge a favorable report. And thank you, Mr. Chairman.
Thank you. First, we have Byron Warnken.
Thank you, Mr. Chairman. Good afternoon, members of the committee. My name is Byron Warnken. I'm here on behalf of the Maryland Association for Justice, asking for a favorable on this bill. The most important benefit of workers' compensation is that the injured worker has their medical treatment paid for. Employers and insurers can challenge medical treatment, and they do. And they do so with counsel in virtually all circumstances. A level playing field demands that injured workers have attorneys as well. Claimants' attorneys take up the fight, and they cannot be paid even if successful, if the only issue is medical treatment, which it often is. Moreover, in circumstances where claimants are unrepresented or the defense or the carrier knows that they're not going to be able to find an attorney, they are more likely to arbitrarily and capriciously deny medical treatment. There are quite a few circumstances where medical treatment is the only benefit that can be obtained. I personally receive calls from injured workers who are in this situation regularly. Therefore, I must, because of a quirk in the law, I must decide whether I'm going to represent that individual pro bono or whether I'm going to turn them away. An unfortunate reality is that most get turned away, and most other firms are in the same boat. And ultimately, when they get turned away and the comp carrier doesn't pay for medical treatment that they are supposed to be paying for, it's often a public benefit payer, a Medicare and Medicaid, that winds up footing the bill for that injured worker. And that's not fair to anybody in the system, including the citizens of Maryland. Thank you for your time.
Thank you. The next witness is Matt Pavla.
Thank you, Chairman Wilson. Appreciate it so much. I'll give something the anecdotal that Mr. Warnken didn't give, his fine presentation, and of course, Delegate Veteramos gives us the overview. Now, let me tell you something that just happened yesterday that illustrates why this is an important bill and why the Maryland Association for Justice is in favor of it. I was at a hearing yesterday, and there before me came one of these unrepresented injured workers. I say before me, I was in the galley waiting for my case. She had a very severe injury, and there was staunch opposition from the insurer and employer to oppose the treatment she needed. So as a practical matter, what happens is the commissioner is caught between a rock and a hard place. They want to have compassion for the injured worker, yet they're struggling with the rules of evidence. And of course, there's a lawyer there. So they bend over backwards to do justice. And I saw that happen yesterday. The commissioner, and very uncomfortable, trying to find a middle ground, and almost didn't advocate, but was close to it almost. So they're in an uncomfortable spot. So I would submit to you, to a person, they would love to see this. Commissioners would love to see this bill passed, I dare say. Thank you very much for the opportunity to speak.
Thank you very much. I appreciate you realizing, although the timer wasn't on, you were very succinct. So thank you very much. James McAllister.
Yes, certainly, Mr. Chairman.
there's not much else I have to say other than this. What I'm hearing today is that the defense bar and the defense lawyers and the insurance companies don't contest these claims. They accept it when it's reasonable to accept it. And they basically pay everything as it comes through the door. They don't challenge PTSD claims. My experience over the last 30 some years has been otherwise. And it's not because they're bad people. It's because that's the way insurance works. Insurance works by only paying those claims that they believe they ought to pay. And when there's a chance not to pay a claim, they don't pay it. It's that simple. That's how they keep their job as an insurance adjuster. So here's what happens. Somebody an injured worker needs a surgery, and no lawyer takes it because they can't get paid. And by the way, they can't even get their expenses reimbursed. So if I spend $35 getting the records from the treating doctor that would be needed to prove, I can't even get that reimbursed. So not only do I have to volunteer, I have to go out of pocket to help these people. So I say, I can't do it. So what do? They go to the commission all by themselves with a shopping bag full of medical records. And as well-intentioned as the commissioners are, the rules still apply in terms of what you have to present. So the claimant isn't going to win. They're up against a seasoned defense lawyer. So what do? They put it through health insurance. They put it through medical assistance. They put it through Medicare. Or worse than that, somebody who needs health care to get back to work simply doesn't get it. So all we're asking is that if there's going to be a fight, and if the insurance company picks that fight by denying health care, and my client has to get a lawyer so that my client can go in and my client successfully proves that this is something that should be paid, then we need to reward and award the attorney for the time invested in proving that, so that the taxpayers and the health insurance paying public don't pay that bill. It's paid by the insurance carrier who collected the premium. That's the comp carrier. Thank you.
All right. Thank you for not having much to say. You said a lot. Thank you very much. Next will be Carmen D'Alessandro.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Carmen D'Alessandro again for Chesapeake and Iowa here to respectfully oppose Delegate Valderrama's bill. I appreciate continuing this conversation from last year. While I don't necessarily oppose the trial bar getting increased fees, I would respectfully say that all other fee matters are handled by regulation with the commission. This would be a complete one-off where one piece of the fee structure is in statute while everything else is in regulation. Just to give you some background, in the last 5 years, we, meaning Chesapeake and Iowa, and we have about 30% of the workers' comp workload in the state of Maryland, have averaged about 6 cases a year where an unrepresented claimant has come to the commission seeking medical treatment. So as you can see, this is not a significant issue that is inundating the commission. Since we last spoke last year and were asked to see if there was some sort of middle ground we could come to, the commission changed their regs in 2 significant ways. They increased the fees for settlements by an extra 5%, thereby giving the claimants more of a pool for fees. They also added, and this is significant in terms of what Delegate Valderrama alluded to, there's a frivolous issue section now where the commission can penalize an insurer for taking a case, as Delegate Valderrama did, for basically an unfair reason. So if an insurer is coming there just to basically roll over an unrepresented claimant and the commission thinks that's what's going on, they can award a fee to the claimant's attorney. Lastly, they were in the process, and I will speak for Chairman Allman, of amending the regs even further by increasing the fees, but the average weekly wage for state of Maryland was increased by 30%, thereby increasing all the other benefits. So that last portion, Mr. Chairman, was put on hold, and I believe it will be reviewed again in the coming year. For those reasons, I would respectfully oppose this bill. Thank you very much.
Delegate Ahrens.
Thank you, Mr. Chair. This is a question for anybody, actually. I have a constituent that he's been severely destroyed. His life, can't work, can't do much, but he cannot get a lawyer to take his comments to anyone because that lawyer's not getting paid. So he has health problems, And he has no real vehicle other than to go find a lawyer, which he has a lawyer assigned, but they don't want to do the job because what you're saying is true. They don't get paid. And there has to be a cause for that. And changing lawyers seems to be a very, very difficult thing in our workman's comp. Is this bill going to address that in some way or some form?
It's a good question, Delegate. And I think that this bill is designed exactly for your constituent. Because if your constituent called an attorney, and after this bill had passed, yes, we'd be happy to represent you. Again, right now, I'm forced to either represent him pro bono or turn him away.
Okay, but what will this bill?
Delegate Aaron's, I think what's important to realize here is that attorney has already been paid. There is a max fee on every compensation case that approaches around $20,000. My friends on the other side would know that better. It's around $20,000. So in that situation, the attorney for your constituent has already received the max. We would expect that attorney to follow through with the case. So it's not as though there's been nothing paid. They've already been paid the full fee allotted by the regulation.
Gentlemen, no, well, wait. We're not, this was a specific question asked. Please try to, direct your questions to whoever. So if you throw them out into the ether, we'll get a long conversation that we probably don't need. So again, Delegate Aaron's, did you get your answer to your question?
One of them, I can.
I know you have several, sir. I know.
My only other question would be is, I understand, and I'm actually breaking the rules here, Chair, a little bit, because what Mr. D'Alessandro said is true. These people get paid, but now they paid not enough. They've been working with this person for several years. And if it's okay with you, I'll stick with Mr. D'Alessandro. They've been working with this lawyer, and if they change, they have to go back to square one. There's something that needs to be done, and I don't know what it is. And I'm not saying this bill is it, but this bill certainly is addressing part of my issue.
Isn't that so?
Isn't that so, Mr. Chairman? Thank you.
Thank you very much. I believe that's a pretty much a good statement. But thank you for your question, Delegate Aaron's. I'll go on to Delegate Howard.
How long are these cases? I mean, is this going to be an industry that crops up where, the lawyer kind of shows up for a day, tries to help the client walk through the procedure, walk through some type of preliminary procedure, maybe, or forget preliminary, walk through the trial procedure, walk through the hearing procedure, and then gets $2,000? And
these cases go on for the life of the claimant. So from the date you're injured until the day you die, you have lifetime medical coverage.
Right.
So, that's how long these cases go on. So if the claimant, is 80 years old and needs medical care and it's related to a back injury, the insurance carrier for the workers' comp carrier has to pay for it if the claimant can either persuade the workers' comp insurance company to approve it or go to a hearing and convince a commissioner to approve it.
So the attorney shows up at the hearing.
Right. Well, the attorney gets the phone call from the client that says, I need to see a doctor. The attorney then goes to the insurance company and says, my client needs to see a doctor. The insurance company either says yes, or the insurance company says no. Then I go to a hearing, if they deny it. If they approve it, he sees the doctor. Now the doctor says the client needs surgery. Now I go to a hearing to see whether the surgery is going to be approved. So
I'm just wondering if we're getting into and I understand what's going on. I don't want it to happen. I think people need to be paid, and I think people have a right to be represented. But I'm just concerned there's no language in the bill, and I don't know how there would be to address a sort of a checklist designed by attorneys. Have you talked to this person? Have you talked to that? You've been refused here. Okay, great. When's your trial date? I'll show up. Be awarded $2,000 because I showed up with you at the trial. That's, if I'm totally off base, let me know.
Chairman, may I reply, please?
Again, guys, I'm trying to get these questions directed to specific individuals because this can be done offline or we can have a conversation. We have roughly 60 more witnesses to go in other hearings. So if we can get a narrowed question and a narrowed answer, that would be wonderful.
May I give a narrow answer?
Delegate Howard, did you get your answer? Would you like something more?
Well, I mean, we were told earlier we're not going to be able to kind of rehear these in subcommittee, so I would like to have something more.
That's why I'm asking, buddy.
Thank you. So may I then, Chairman?
Please.
Thank you. Succinctly and directly, The bill does address your concerns, Delegate Howard, because it's in the discretion of the commissioner. And if it were a 15-minute hearing that lawyer just showed up, maybe was there on another case and said, here, let me help out, and volunteers, they would get a very small fee. $200-300, discretion of the commissioner. If it was extensive and a lot of testimony and it went back and forth and there was a lot of preparation, the commissioner could give up to $2,000. Unlikely, it would be very rare it would get to the $2,000 in my humble opinion. Thank you.
Are you for the bill or against it?
For it.
Okay, I want to hear from somebody against it based on my
I
question.
also want to say this. Let me clarify. While our subcommittees are not public hearings, our very powerful delegates can ask whichever advocates they want. They can be there. They can attend these hearings. They will attend these hearings, and you can ask them for information. We're just not there to let them present additional information that was not presented. So, good delegate, you'll be free to ask these individuals any questions now or also in subcommittee. I'm not trying to truncate what you're saying. I'm just saying I don't want to think people that you can't ask questions. So please go ahead. But you can also ask them to come to subcommittee and make sure we clarify it, because things do evolve.
Well, the question's out there, so let's clarify it now.
You might want to ask it again.
I want to know from somebody who is not a proponent of this legislation if what I'm saying has any merit. Are we creating an industry here where it's going to be one attorney representing 5 or 6 clients with up to $2,000 awarded to that attorney a day, a week, based on this fund, which is going to be probably wholly subsidized by employers and taxpayers?
Delegate Howard, this is Carmen D'Alessandro. I think I'll respond because I think I'm the only opponent that's testified so far, but I would certainly yield to the others coming. As I stated, with only 6 of these instances coming up a year for us, I am concerned that with all types of laws or all types of the creation of some sort of cottage type industry where there will be more and more litigation that is not occurring today. Again, we don't have any significant evidence of people not getting their medical treatment because they were unrepresented. Like I said, we have very few cases, but obviously this bill would allow for the increased amount of litigation around this subset of issues.
Okay. All right. Thank you.
Delegate Howard, thank you as always for your cherubic demeanor. We will move on. And I think next we have Julie Murray.
Thank you very much, Chair and Delegate. Julie Murray again on behalf of the Maryland Defense Council. I would just like to start by clearing up a few things. The claimant's attorneys are paid for these hearings that they attend. As with most types of litigation, claimant's attorneys are paid at the end of the case when they get to indemnity. So if there are several hearings over the course of the years where there's medical treatment being sought, they get a fee after those hearings are done and they get to the stage where indemnity benefits are sought. As Mr. D'Alessandro mentioned, the notion that there are all of these claimants out there unrepresented that are just struggling to have their cases heard before the commission is not entirely correct, because most claimants' attorneys do represent them for the life of the claim and are paid each and every time indemnity benefits are awarded. We only see a small handful of cases, I think what Chesapeake indicated, about 6 per year, where they are truly unrepresented and can't find an attorney. The other important thing that I would like to reiterate that I was asked to address is that this was acknowledged to be an issue and it was rectified by the Workers' Compensation Commission when they recently updated COMAR 14090403, raised the cap on attorney's fees so that an attorney can now get up to $50,000 for a fee, and they increased the amount they can receive on settlements. The commission has always and historically handled these attorney's fee disputes through COMAR. They have always handled them themselves. They have addressed issues with the amount that claimants' attorneys are seeking before them. And this bill would be the very first time ever that we've gone outside of that framework and written an attorney's fee into the statute. For that reason, we would respectfully ask for an unfavorable report.
Thank you. Now get on Michael Daly.
Thank you, Chairman. Michael Daly on behalf of the Maryland Defense Council. Very briefly, there was a statement made that this attorney fee would only be awarded by the commission if the claimant was successful in presenting evidence and receiving an award in their favor. That's not true. If you read the bill, there's nothing in the bill as it stands now that says that the attorney fee can be awarded to claims attorney only if they're successful before the commission. Secondly, it's pretty telling that Chesapeake Employers, the largest workers' comp insurer in the state, has 6 of these claims. Again, we feel like this is one of those situations where there's a lot of concerns raised over a problem that we simply don't see as practitioners before the commission. We believe that this is simply legislation that is seeking a solution when no problem exists. And finally, we give great deference to the commission and the chairman and their abilities to properly pass regulations. They've done it most recently, as already pointed out, to assist the injured workers and to allow the claimant attorneys to receive an increase in their fees. The Maryland Defense Council certainly supports that. We're not standing in their way. We think the COMAR provisions are the way to go if there's any further changes that are necessary. For those reasons, we're asking for an unfavorable report. Thank you for your time.
Next, we have Ashley Smith.
Thank you, Mr. Chairman. My name is Ashley Smith, and again, I'm with the Maryland Defense Council. I will be brief. I just wanted to respectfully remind the committee that the purpose of the Workers' Compensation Act is to protect injured workers. And that means they're being protected not only from the predatory insurance companies that everybody complains about, but also from the excessive fees potentially imposed by their attorneys. In this case, the commission is charged with doing that by regulating the fees, when fees are payable, when fees are not payable. And the commission has spoken clearly by saying they don't believe that you should be able to receive a fee when it is medical treatment only, absent extraordinary circumstances. There is currently a provision in COMAR where claimants' attorneys can file a fee petition and receive reimbursement or of a fee in the event that there is an extraordinary circumstance where they are not entitled to recover indemnity benefits. I would also point out that the Maryland Court of Appeals in the case of Feisner versus Prince George's County was issued in 1978, has noted that there is no statutory right to payment for legal services in the Workers' Compensation Act, and that injured workers are only entitled, their attorneys are only entitled to receive compensation if and when an injured worker receives compensation. That is the way it has been with plaintiffs' attorneys for as long back as the system goes. And as Ms. Murray previously indicated, in this case, injured workers' attorneys are receiving a payment. They receive it at the end of the case or up when indemnity is awarded. They just don't receive payment on a per hearing basis. If this legislation is adopted, we would be essentially converting it to they get paid per appearance, which is not the intention of the act or the commission. And it is that way on purpose in order to protect injured workers. And for that reason, we would request an unfavorable report.
Next, we have Robert Erlinson. Mr. Erlinson, are you available? Moving on, Brianna January.
Okay, am I unmuted? Okay, I'm sorry. I just want to big me too. And secondly, I want to emphasize the point previously raised by Mr. D'Alessandro, and that is the ability of the commission to assess fines and penalties in frivolous cases. I think one of the proponents, I think my good friend Mr. Pavela, indicated that the commissioners bend over backwards in situations involving unrepresented claimants. That is absolutely true. And so that therefore, if they have any suspicion that insurance companies or employers are wrongfully denying claims and medical expenses that the claimant is entitled to, they have never hesitated to, one, find in favor of the claimant, and two, assess penalties. So for this reason, I think that this bill is not necessary and I ask for an unfavorable report.
Brianna, January. How about Bill George? That concludes this hearing. Moving on to the next Delegate Valderrama hearing. Delegate Valderrama here, 611.
Thank you, Mr. Chairman. Good afternoon, members. Here to present, Chris Valderrama here to present House Bill 611, which will be applying the Maryland prevailing wage rates to public work mechanical service contracts. That would include plumbing, electrical, HVAC, refrigeration, heating, elevator repair, and similar skilled trades. So if you will recall last year's hearing when we modified the Maryland prevailing wage law for construction employees, we were reminded of the benefits of paying skilled trades workers a prevailing wage. So by paying fair wage, state and local governments, they actually save money for several points. There's less use of public health or public welfare service. There's also an increase in tax revenue because better paying jobs reap more funds to pay for new schools, roads, libraries, et cetera. And finally, prevailing wage participants are mandated to fund quality apprenticeship programs for those who may not want a college education, but who want a well-paying trade skill. So these apprenticeship programs are often an entry point into the middle class and provide our community with the economy, with the skilled workers that employers so often say are critically in short supply. So this legislation is narrowly tailored. So unlike last year's bill that applied to very large contracts over 250,000, this legislation applies to small contracts of around 3,000 to 5,000. And it aligns state law with the federal McNamara-O'Hara Service Contract Act, which requires contractors and subcontractors performing services on contracts in excess of 2,500 to pay service employees in various classes, no less than the wage rates and fringe benefits found prevailing locally. So this legislation also seeks to keep state wages aligned with the wages set in county statutes in Montgomery County and the pending ones in Anne Arundel, Baltimore City, Baltimore County, Charles, and my county of Prince George's. So in hopes of passing this bill, we would be eliminating an unfair two-tier system where the same skilled employee who constructs, say, an elevator will be paid a lesser wage when repairing that same elevator. So the skilled worker performing the repair work still applies the same knowledge and training to both jobs, and perhaps even more so when troubleshooting a repair job, and deserves to be paid the fair wage for this work. So for the reasons I've stated, I would urge a favorable report. And Mr. Chairman, I believe you have the list of my panelists, which are Roger Manos, Stephanie Sweet, Gerald Jackson, Jeff Guido, Jason Williams, and Mr. Joseph Reed.
Thank you for reading them off, Delegate.
Wow, Mr. Vice Chair.
Right as I took over. First up, we'll go Roger Mano. I think I got everybody.
Great.
I was like circling names as you were rattling them off. So Roger Mano. Mr. Mano?
I think he's trying to get on.
All right, we'll come back to him. Stephanie Sweet.
Good evening, ladies and gentlemen. My name is Stephanie Sweet, and I am the owner of Bethel Electrical Construction Company. We are a certified MBE, a minority business enterprise, and a service-disabled veteran-owned small business located here in Southern Maryland. And I'm here today to say that I strongly support House Bill 611. Over the years, Bethel has garnered a real reputation of providing a wide range of superior and cost-effective electrical services, including successful state procurements at Bowie State University. State highway administrations include Laurel, Silver Spring, and Dayton, the Athanasius Building in Annapolis, and the Maryland Department of Labor Licensing and Regulations. Over the years, we have attributed a sincere commitment to safety, quality work, and outstanding customer service. And these qualities have helped our company, Bethel Electrical Construction Company, become the trusted electricians of choice throughout the Mid-Atlantic region for the better part of 15 years. We're signatory with IBEW Local 26 and 24, and we hire union workers because we need the quality, safety, and the on-time scheduling of the work done by these men and women. It's basically simple good business for us. While a significant amount of our work is construction, we also do a considerable amount of government and private sector safety work as well. Our current partnership is with GM Services. And what they do is they provide ongoing leadership and mentoring support through the Mentor Protege program of this Small Business Administration. This legislation we're discussing is critical to our future growth and success because it closes a loophole in Maryland regarding the different wages between construction and service work, although the same workers. By expanding prevailing wages to service work, MBEs like Bethel Electrical Construction can better compete on a level playing field among the contractors that pay lower wages with minimal benefits, if any. In many cases, they cheat their workers through wage theft and misclassification. In addition, by ensuring that prevailing wages are paid on service work, this legislation at hand enables the Maryland Department of Labor full enforcement authority to ensure the critical state tax dollars are being spent as the law requires. And it is this reason, ladies and gentlemen, that we go a long way towards a minority business enterprise like Bethel. And for this reason, we ask that you support this legislation. Thank you very much.
Thank you, ma'am. We'll take questions after we go to Roger Mano first. Roger.
Mr. Vice Chair, I'm just here for technical assistance if anybody has any questions about the bill or the sections of the code.
Okay, Delegate Adams.
I have some technical assistance I need. Roger, are you ready? So let me just say this. I'm very familiar with prevailing wage. Most of us understand the prevailing wage law to relate to larger projects with certain minimums. We've reduced the minimums over time, but we have a bill for service projects around $3,000. And I would simply suggest, and correct me if I'm wrong, this is the question, aren't you excluding many single sole proprietors, small business people that just do service contracts? We're not talking about the big boys that get on multi-story commercial projects. We're talking about ones that are only able to handle so much work, and the kind of work they do, they're very good at it. But to go through the rigors of prevailing wage law, the reporting requirements, and for the one of service work just seems like a bit much. Would you agree or disagree?
Thank you, Delegate Adams. You'll hear from several small contractors this afternoon who can speak to that issue specifically. This is only for state work. It's not for federal work or county work. And we believe that by expanding prevailing wages to the service contract realm, you're allowing the same workers who built that building yesterday, who were paid prevailing wages on that state construction contract, same level of licensing, same level of skill, same level of certification. That worker the next day would be paid probably living wages, which, as you know, tier 2, tier 1 is $10 and $14 an hour, something like that. So it makes no sense that on one day when a building is being built, let's say an HVAC system is being installed, that would be a prevailing wage project, state project. The next day, the service end of that work would be a whole different pay scale for the same worker with the same level of training.
Well, the only thing I'd say, and I'll just close by saying that over my 7 years, I've seen us draw new lines in the sand as it relates to prevailing wage. This essentially removes any line in the sand. You're plotting for every single project, and you will exclude many, many, many businesses in the exercise. Thank you, Vice Chair.
Thank you. Jeff Guido. Okay, Gerald Jackson. All right, Joseph Reed, I see you.
Yes. Good afternoon. I'm Joe Reed, minority owner of J&R Solutions, HVAC Services, based out of White Plains, Maryland. The prevailing wage bill is very important from my perspective as a young, up-and-coming minority owner to be able to obtain service contract work, which is the main line of my HVAC work. Local 602 wages, health benefits, and retirement are a great opportunity in career. I came up through the ranks at Local 602, first as a helper, straight out of high school, and then got accepted into the apprenticeship program. I graduated and became a journeyman in 2015. After graduating my apprenticeship program with the help of Local 602, I got my Maryland HVAC master license back in 2018. I then became a Local 602 minority owner in October of 2021. The Local 602 has helped me with my transition into business by assisting in getting myself and my company opportunities to obtain service contract and repair work. So that is why I support this bill to open the door for all minority contractors to be able to obtain service work after the completion of construction. With prevailing wages, we will be able to competitively bid on service contract and repair work. Thank you for your time.
Thank you, sir. Jason Williams.
Good afternoon, Mr. Chairman, C.T. Wilson, and committee members. I support this legislation because expanding prevailing wages to mechanical services will open more doors for opportunities for people like myself. And when I speak of myself, I'm speaking at 29. I made some mistakes and some decisions I'm not proud of. And I was incarcerated or actually sentenced to 31 years. I ended up doing 11 years and 8 months, which is over a quarter of my life incarcerated. It was a long road, but I think that looking back, I had to go to a place with no windows to get a real perspective in life. So during incarceration, I decided to take a vocational welding program. I excelled, and just by chance, I was visited by a childhood friend whose wife was a member of the UA Steamfitter 602. She suggested that I take welding or pursue welding through the union once I got out. So I immediately began to take time to practice for the apprenticeship test. Once I was released, I took the test and I was accepted into the training program. After that, I was called to work and I've been working ever since. Through the training, I've met other people who have come along the same roads I have and have taken their time through the apprenticeship program to improve their lives. And really from a deeply personal point of view, the training program has given me times in my life feel freer to do the things that I need to do as far as a paycheck to take care of my daughter, who I was incarcerated and taken from when she was 2 weeks old. And also helps me to understand my place in the world and help people to understand their places in the world and things that are available to them. So this legislation expands programs like mine, and it helps people like me earn good wages in both construction and in service work. And it relates directly to this legislation. So please do everything you can to pass. And thanks for your time.
Thank you, sir. And I appreciate you coming here today, sharing your story. Gerald Jackson.
Can you guys hear me?
Yep, I see you on. I saw you on the first time too. Go ahead, sir.
All right, thank you. I just want to greet the chairman and vice chair Crosby and the committee members. My name is Gerald Jackson. I'm the secretary treasurer for the Maryland State and DC AFL-CIO under leadership of Donna Edwards. I'm speaking today in my official capacity as the assistant business manager for Steam Fitters and Plumbers Local 486 here in Baltimore. And on behalf of our 2,500 members and over 100 contractors, I'm asking for a favorable report on House Bill 611. This legislation is necessary to resolve confusion in the Maryland State Code as to whether service contracts are subject to prevailing wages. I'm gonna skip everything I wrote. This legislation parallels the federal Davis-Bacon requirements stated in the McNamara-O'Hara Service Contracts Act. What I will say is supporting this bill ensures that thousands of Maryland residents, irrespective of union affiliation, will earn a package including life-sustaining wages and benefits. And the reason that's important to me is because most labor bills are perceived to be for unions only, and that's not true. Union members and contractors have negotiated a package that can benefit all workers. Organized labor only does about 20% of the construction and service contracts in Maryland. So that means that the merit shops are getting the lion's share. Having prevailing wage requirements on these projects ensures that they get life-sustaining wages and benefits also. This is very important. It's not just for unions, it's for all workers in Maryland. Having prevailing wage requirements also ensures that workers who may have language barriers or representative of underserved communities have protections under the law that guarantees life-sustaining wages. For these reasons, I would like to have a favorable report on House Bill 611.
Thank you, Mr. Jackson. Next up, we have favorable with amendments. Bill George.
Good afternoon to the chair, vice chair, members of the committee. My name is Bill George with the Maryland Municipal League. Today here in support with amendment on House Bill 611. MML is not often involved in legislation regarding the prevailing wage, as many of our members already pay workers a prevailing wage on construction projects voluntarily, and others rarely have state subsidized public work projects that exceed the current $250,000 threshold. But there are some municipal projects that currently do qualify as mandatory prevailing wage projects. The provisions of this bill, however, would have broad applicability to municipal governments and the management of their facilities. The impact will be felt across our membership, but particularly in the smaller municipalities with limited budgets. This bill expands the definition of construction to include certain mechanical services, which is not particularly troubling. However, it also institutes the new low threshold of $2,500 for mechanical systems work, while keeping the state share the same to qualify for the prevailing wage, which is concerning to some degree. The current prevailing wage law, as has been mentioned, deals primarily with large capital projects that receive 25% state funds. But this new lower threshold for mechanical systems work captures ongoing operational expenses for electrical, plumbing, or HVAC work, among others. Our proposal is for an amendment that raises the $2,500 threshold dollar amount for mechanical systems work to something more elevated, to keep it more in line with the capital projects that are found in the current prevailing wage law and away from the ongoing routine maintenance. We're happy to work with the sponsor, members of the committee, on finding that exact dollar figure. And as such, MML requests a support with this important amendment on House Bill 611.
Thank you. To the unfavorable, Brianna January.
Hi, Committee. Brianna January here again with the Maryland Association of Counties, this time in respectful opposition to HB 611. I'd like to clarify some confusion that seems to exist about the parameters of the bill as currently drafted. To be clear, the bill would apply to local services, not just state. The bill requires prevailing wage to be applied for maintenance if the construction of the facility was under prevailing wage. Current law dictates that if the state partners with local governments on construction, even as just a minimal partner providing only the very small amount of 25% of total costs, then prevailing wage is paid. So for context committees, this captures most school construction projects, for example, and a lot of other capital projects where the state partners with counties, even at just that very minimal partnership of 25%. So as you can imagine, this bill would in fact apply to a wide swath of county service work. That said, counties already have the ability to apply the prevailing wage for maintenance contracts, and several already do. MACO is simply asking that counties continue to have that flexibility and not be mandated to do so, which simply put may not be appropriate policy for all counties, each of which operates under different regional market and economic realities. Counties, as the owner and operator of public facilities, already implement complex operational and fiscal systems to manage our facility maintenance. These systems are uniquely tailored to the needs of each jurisdiction, and they take into consideration these important regional differences, such as local markets and costs. Unfortunately, HB 611 does not take these factors into consideration, and the bill would undo the current reasonable approach and instead prescribe a uniform one-size-fits-all policy to all of our county facility management work that falls under the bill's requirements. So committee, for these reasons, MACO does urge an unfavorable report. Thank you.
Thank you. And that concludes the hearing on House Bill 611. Next, we'll go to House Bill 640. Delegate Carey.
Thank you. Thank you, Mr. Chairman. Good afternoon, Vice Chairman Crosby, members of the committee. For the record, I'm Delegate Ned Carey, here to present House Bill 640 today. And I'll be brief. And I would just like to say that the Healthy Working Families Act generally provides for up to 40 hours of leave during a calendar year. The leave is accrued at the rate of 1 hour for every 30 worked, and all Maryland-based employees are entitled to accrue sick and safe leave, except for employees that are specifically exempted. House Bill 640 addresses the specific exemption that applies to construction laborers covered by a collective bargaining agreement and seeks to end that exemption. Ending the exemption would prohibit the current practice of contractors almost universally demanding a waiver from the Healthy Working Families Act for construction laborers, requiring unions to bargain for their sick and safe leave. Now, sick and safe leave would now be provided without surrendering the compensation or other benefits. As we all know, construction laborers are the unskilled workers in the construction field, setting them apart from skilled workers like electricians or masons. They're generally the lowest paid construction workers and often tasked with the most physically demanding jobs. Because they are exempted from the act and the unions are required to negotiate sick and safe leave, that becomes a part of their fringe benefits. Consequently, construction laborers must give up some other benefit while all other Maryland employees receive that benefit. You know, in this bill, or right now, construction workers is not defined in the current law, creating an opportunity for confusion about who a laborer is versus a skilled worker. To clear this up, the bill adds definition of what a construction laborer is. In closing, laborers shouldn't have to pay to obtain these benefits. They should be treated like all other Marylanders, including non-union construction laborers. This legislation would simply guarantee that all construction laborers would be entitled to sick and safe leave, just like every other Maryland employee. And with that, I would ask the committee for favorable consideration of House Bill 640. And Mr. Vice Chairman, I have a panel of Steve Leininger and Steve Leining and Brett Leininger to also testify as my panel.
Yeah, say that 10 times fast. So I have the order here, and we'll go to Steve Lanning first, and then next we'll do you, Brett.
Thank you.
Vice Chair Crosby and members of the committee, thank you for the opportunity to testify on HB 640. My name is Steve Lanning. I'm the Assistant Business Manager of Labor's Local 11, an affiliate of the Laborers International Union of North America, or LIUNA for short. Local 11, combined with our sister Local 710 out of Baltimore, represents more than 4,000 construction laborers who live and work in Maryland. You see us every day working on our region's infrastructure projects, including BG&E and Washington Gas pipeline replacement projects. And we expect to be working very soon on the Purple Line Rail project. LIUNA members support HB 640. Currently, the Healthy Working Families Act allows construction workers who work under a collective bargaining agreement, or CBA, to waive the requirements of the Maryland Earned Sick and Safe Leave Law. HB 640 seeks to remove that exemption only for construction laborers. The bill does not affect any other provision of the Maryland Healthy Working Families Act. To be clear, the construction labor position is a distinct construction craft. For example, other types of construction crafts include carpenters, electricians, and plumbers, to name a few. Generally, laborers are the lowest paid craft among construction workers. The labor position is often viewed as entry-level and easier to replace compared with skilled crafts like electricians or elevator mechanics. Consequently, from the very outset, construction laborers are disadvantaged during their CBA negotiations with contractors. When you bargain, you're expected to give something up in exchange for something else. LIUNA strongly believes that sick leave should not be on the negotiating table for construction laborers during CBA discussions. The potential for sick leave to be taken away from a laborer, typically the lowest paid position on a job site, during collective bargaining negotiations is bad public policy, especially during a pandemic. On behalf of our members, please issue a favorable report on HB 640.
Thank you, sir. And just a reminder for future testimony, your camera does have to be on, and for everybody going forward. Well, there you go, right at the end, just to make sure your camera's on as you're testifying. Next, we have Brett Leininger.
Thank you, Mr. Chairman. Can you hear me okay? Okay. Thank you. Brett Leininger here on behalf of LIUNA, echoing the sentiments of both Delegate Carey, and thank you very much to Delegate Carey for introducing the legislation, as well as Mr. Lanning. Just simply put, really there should be no situation where a laborer should have to negotiate these types of benefits. they're negotiating on wage, insurance, and other fringe benefits, and we feel like they should be dealt with and exempted or incorporated into the Healthy Families Workings Act. And as was mentioned before, the Maryland Department of Labor provides the list of individuals who are classified as laborers, so there would be no ambiguity as to who is a laborer for purposes of this legislation. And with that, we urge a favorable report.
Thank you. To the unfavorables, Champ McCulloch.
Thank you, Mr. Chairman. Champ McCulloch on behalf of the Maryland Associated General Contractors. I've had the good fortune of being part of collective bargaining with the laborers, and with specifically Local 710. And one thing I can assure you is that the laborers union is a very sophisticated, very competent, very well-staffed organization. So when you sit down at the bargaining table, you have two equals dealing with the issues that are presented. The reality is that in bargaining, as one of the prior witnesses said, you give up something and you get something. But it is a voluntary action. Nobody's being coerced here. And so the laborers do not have to agree to a change that affects their health coverage if they don't want to. But if they do, it's because they have made their own independent determination that something else that was the subject of bargaining was more valuable. Now, and I don't mean to be a cynic here, but essentially what the laborers are asking the General Assembly to do is to say, well, give me this. I won't have to bargain for it. So now I've got more leverage to get something else from the union contractors. That's not an appropriate role for the state. And accordingly, I would respectfully request that the committee give the bill an unfavorable report.
Thank you. And seeing no questions, that concludes the hearing for House Bill 640. My apologies, Delegate Walker.
Thank you. I just want to hear, going off of Mr. McCullough's testimony, if maybe Mr. Lanning wants to respond. Is it true what he's saying? And it kind of seems like it could be. And is that the ploy here, or what do you think about what Mr. McCullough just said?
I would, I guess, respectfully disagree in that, right now, because the law as written has an exemption for construction workers covered by a collective bargaining agreement, unionized construction laborers seem to be disproportionately targeted in this, as opposed to, let's say, a non-union construction laborer who is guaranteed this by law. So it's, in that regard, leveling the playing field for non-union union construction laborers. It's basically kind of cleaning up, I guess, an unintended consequence of the law. And again, just going back, as my testimony indicated, I mean, construction laborers, if you think of the workforce within a pyramid, the more skilled, the more desirable, the higher your wages, bargaining power is. Construction laborers generally are at the lower end because of how it's viewed, licensing, what have you. This, number one.
Let me ask you this. Let me ask you this, because I done woke up some of the sleeping giants in the room, it looks like. Let me ask you this. So you're saying, for my clarification, so non-union construction workers have this benefit. Unionized construction workers do not have it.
Let me clarify. All right, non-union construction workers by law, yes, by law are covered by this act.
Okay.
Unionized construction workers, there can be negotiated, the sick leave can be negotiated out of the collective bargaining agreement, basically exempting them by coverage under the law.
Okay. All right. Thank you.
Thank you. Just a reminder before we go to Delegate Arentz, the chat is for members and committee staff. So just make sure, or just reminding everybody on here. Delegate Arentz.
I think, didn't we deliberately exclude them when we did paid leave a few years ago? I think they were deliberately excluded from this bill, the paid leave bill, and now conveniently they went back in on it somehow. And I would tend to agree with Mr. McCullough on this, that you had the opportunity a few years ago when we did paid leave, and you were excluded for a purpose, and I'm not clear what that purpose was. I think it was because you already had something like it. Now it seems like you're asking the legislature to come back in and help you do something you might have made a mistake on a few years ago. And I think I would lean with Mr. McCullough's version of this, that you had the opportunity, you negotiate those, and you negotiated yourself out of it before. Now you want back in. Isn't that so?
I would, Ms. Delegate, I guess, disagree insofar as other building trade unions, and there's 15 building trade unions, agreed, I guess, with, this opportunity to exempt respective construction workers covered by CBA from coverage. We didn't agree with that, but the law went through. So we're basically trying to come back with our position now.
I don't recall you testifying, anybody coming in on that back when we did these bills, that was a problem back then, and now it's a problem. So I just want to make that clarification. Thank you very much. Thank you, Mr. Chair.
Thank you, Delegate Adams.
Thank you. And I guess to Luna, the thing that I found, actually, there were a lot of problems with the bill, but the one that actually created the exemption was really distasteful to a lot of us at the time, because I think what it acknowledged was the realities of job site conditions, the ability of workers to, irrespective of whether they're merit or union, being able to advocate for their best interests. And ultimately, and this is the question for you, if you're the union, what you're saying is, okay, you don't get the paid leave, we're going to give that to you in the form of higher compensation by the hour or some other fringe benefit that's important, like healthcare. And so I got to say that the problem remains in the construction industry, and it's almost exactly the way you've articulated. And that is that the bill is tough to implement on construction projects, and it's why you're here. It's almost like I wish you were here when we were having the bill hearing a few years ago, because you're expressing the issue in the construction trades point blank.
Yeah, Mr. Delegate, I would just, this is just related to the classification of construction labor. Again, that kind of entry-level position.
Well, Steve, the point is I can bring a bill in for any trade and have the same argument. Mr. Chairman, Vice Chair, thank you very much.
Thank you. That concludes House Bill hearing, or hearing for House Bill 640. Next, similar to what we did earlier on House Bill 614 and 628, or at least tried to do, we have two bills that are very similar in how they came in. House Bill 08, which is Delegate Valderrama, and House Bill 496, which is Chair Wilson. So we will first go to Delegate Valderrama, then Delegate Wilson will give his brief, and then we will go through the witnesses, both then favorable, and then flip to favorable with amendments, and then at the end do unfavorable. So we'll hear these two bills in the same hearing. So first up, House Bill 08, Delegate Valderrama.
Thank you very much, Mr. Chairman. And in the last several bills, I tried to move along quite swiftly. I may not do that on this one, on this particular piece of legislation, although it is not new to the committee. This one I'm even more passionate about. So with that said, esteemed colleagues, Chris Valderrama here to present House Bill 8, the Family Paid Medical Leave Program, also known as the Time to Care Act bill. So before I give my testimony, I just want to introduce my virtual sponsors panel, who will be speaking following me and can answer your even more detailed questions, should there be any. Ms. Regan Vaughn, who's an attorney with Catholic Charities, she's been involved in the drafting of this legislation from the start and can answer any technical questions about the provisions of the bill. Ms. Molly Williamson is with a national organization called Better Balance. And finally, Kaylee Schmitz is with the Maryland Center on Economic Policy. She will be our numbers person and can answer questions about the funding of the program, as well as benefits payable for each income level. So most of you will recall this piece of legislation. This is, I believe, the third year that I have brought it forward to the Economic Matters Committee. I had predecessors before me who have presented this bill. So I think in all, this bill has been presented over 7 years. And this is a product of a task force that was created in 2017. So in each of these years, opponents advanced various reasons for opposing the bill. because as it was said, the time was not right. I personally couldn't disagree more. I've always thought that the bill was timely, and especially even more now. So have often said when speaking about paid family leave that all of us will either need the benefits of this bill or, we'll know someone who will. But regardless, as I've said over the years, the rain falls on each of our heads. So COVID-19 has surely illustrated this point. For me, this bill is personal. I don't often tell my personal stories because it's difficult for me. I've done it in the past. I will make it very brief. But as many of you know, several years ago, my mother now is in heaven. And it was at that time from a former employer where I took a lot of my accrued vacation and sick time to be there in her time of need. And so my employer at the time was not particularly understanding. And even though I had earned the time off I took to assist my ailing mother, they questioned every day that I sought to use my benefits. So I don't believe that our Marylanders should go through this kind of scrutiny to assist a family member, a loved one, whomever it is in your family. So, graciously, I was one of the lucky ones. My former employer, although my benefits were pretty generous, it ultimately proved to be inadequate for my personal circumstance. Most folks don't have generous benefits, and that's who I am looking after with this legislation. The statistics on sick leave and family medical leave are bleak and unequal, and sadly, the United States is the only advanced industrialized nation without a federal law providing workers access to maternity leave, and one of only a handful of nations that does not offer broader family and medical leave insurance. So in the US, fewer than 40% of workers have paid leave for short-term disability. Only 23% have access to paid family leave, and nearly 25% of women take 10 days or fewer for maternity leave. The Federal Family Medical and Leave Act, FMLA, which was passed in '93, that was groundbreaking, and it was heralded a great advance for employees of all pay grades because it guarantees workers up to 12 weeks of job protected leave to recover from a serious illness or care for a newborn, care for an ill family member, such as my case, or for a member of the military. But what is often misunderstood and maybe forgotten is that while it was a heralding measure, it's unpaid. And unless you have adequate means or adequate benefits, it's very unlikely that you can take FMLA leave, even if you are entitled. So the Time to Care Act of 2022, what does it do? The essence of the bill, again, for a relatively small amount of money, employers, employees, and some self-employed individuals can obtain an insurance that will provide a partial wage replacement when they need time away for the reasons that I aforementioned. It's a self-funded plan. No state funds are involved. Startup and ongoing administrative costs are borne entirely by the program. Contributions will be collected from the bill's effective date, but would not begin paying benefits until a year and a half after that date, so that funds could remain actuarially sound. Contributions and benefits are paid and received on a sliding scale. The contributions and benefits are paid, I believe I said on the sliding scale, but the maximum that anyone will pay under this bill is between 0.67% and 75% of their pay, 0.75%, 0.075%. This comes out to between $19, $21 per week, split evenly between employer and employee, means that each would pay approximately $9.50 and $10.50, and that rate is for an employee making over $147,000 per year. As I mentioned, we have someone with us who will break down all the numbers, but again, I just want to reiterate that these are not hourly payments, nor are they daily charges. They're weekly contributions. And I'd like to note that what makes the plan affordable for an employer is that they don't have to pay wages while an employee is using these benefits. Employers can use those dollars saved by their employee's absence to hire temporary replacement or pay other employees for added hours to make up for the employee's absence, or they could do neither. And so to be clear, some people may never use this insurance, but that's the nature of an insurance policy. Some people don't need it or don't want it. Some already have more generous benefits, as I did, but it didn't turn out to be the case in the end. And some will not be able to afford to use this policy because they can't live on a partial wage replacement. So few final points. I know I mentioned this maybe 2 years ago, but worth mentioning now. This insurance is tremendously popular among the citizens of Maryland. There were 3 recent polls conducted by the advocacy groups and the policy organizations such as SIX have shown a consistently high approval rating. The Time to Care Coalition poll showed overall approval rate of 88%, including, and I'd like to emphasize, a whopping 77% approval by registered Republicans in Maryland, even when it was, the respondents were told they must make a weekly contribution. So 77%, that's nothing to ignore there. So moreover, poll numbers show that our experience with COVID may have created a higher level of urgency and support for this legislation. So perhaps maybe one of the legacies that COVID is that it has made it abundantly clear that families, and particularly women, have inadequate leave to deal with difficult family challenges. And so there are some who will testify today who will undoubtedly say, again, the time is not right to implement this program. It's too expensive is one argument, and neither employer nor employee can afford 1 more cent out of their payroll or paycheck. Yet those same people have said, being respectful here, have said that same tired line for the last 4 years. So well before the consequences of this pandemic shook our world. And I'll just end by saying that this isn't the time to implement an innovative and affordable paid sick leave program, then when is the right time? Because we're in it right now. So for all those reasons and the information I provided and the expert panelists with me, I urge a favorable report on House Bill 8.
Thank you,
Mr.
Delegate.
Chairman.
Thank you, Delegate Valderrama. And if you could just text me your panel. Next, we'll have House Bill 496, Chair Wilson.
And thank you, Mr. Vice Chair. I will be very brief for the members because this is a very similar bill. We basically did a study over the summer and worked with the drafters. We addressed the issue of the small businesses by excluding anyone with 15 or 14 or less employees. Employers with less than 15 do not have to participate. It does allow self-employed individuals to also contribute. And instead of 0.75, it actually increases it to 1.0% of the employee's wages to be split half and half between the employer and the employee. The math we did roughly for $148,000 is that the employer would pay a maximum of $780 a year for this benefit. And as Delegate Valderrama covered, our bills are very similar as far as the 12 weeks that are available, up to 24 weeks in certain emergent circumstances. And obviously the enforcement mechanism is something that we'll be discussing. And while we have it pretty much employer-based in the bills, I do believe we're going to try and switch the focus over to a state-based enforcement, because I know employers don't want to deal with the enforcement mechanism. And to be fair, as a solo practitioner, if there's the individuals that are ensuring that I'm actually filing a valid complaint should be the same ones that do it for any employee who participates in this program. As Delegate Valderrama said, this is very important. Talking to many young ladies who had family issues, pregnant, things of that nature, the family medical leave, they need that paid family medical leave. FMLA just isn't enough. Leaving their workforce and not having any pay. And this is, again, insurance. You have to pay into it. If you're solo, you have to do it for at least 3 years before you can collect. If you work with an employer, then you have to do it for at least a year. And the startup cost, which is roughly $20 million to keep this to get this going, it's something that will not be borne by the state because it will be loaned by the state but paid back through the collections that we'll be doing. Other than that, that's all my presentation. I know we're gonna have a similar group of witnesses.
Thank you, Mr. Chair. And real quick, before we get to the panel and Delegate Walker's question, I'd like to call Tom Perez, obviously gubernatorial candidate and former Secretary of Labor. Mr. Perez, are you on, sir? Okay, we can come back to him. Delegate Walker.
Yes. Oh, I'm sorry.
Oh, I'm sorry. How are you?
Sorry. Thank you so much. I really appreciate the time, Chair Wilson and Vice Chair Crosby and members of the Economic Matters Committee. First of all, congratulations on your ascension, Mr. Chairman, Mr. Vice Chairman. The committee is well served, and thank you to Delegate Valderrama for her wonderful leadership. I am here to make two basic points. I'm strongly in support of this legislation. As your former U.S. Labor Secretary, I was heavily involved in President Obama's Lead on Leave campaign. And we worked to identify executive action that could be undertaken at a federal level to expand paid family and medical leave. We worked with state and local governments on these issues because so many states and local governments were trying to do the same thing. And what I learned from that is it can be done, it must be done. And I applaud the 9 states and the District of Columbia for doing this. And I hope Maryland will become the 10th state. Secondly, I traveled not only across the country on this issue, but around the world. I spoke with business leaders in Australia. I spoke with business leaders in the UK, in Canada, in Germany. And the reason I did this is because, as Delegate Valderrama correctly points out, we are the only large industrialized nation on the planet that doesn't have some form of paid family and medical leave. And I appreciate the arguments that many of my friends in the business community have made who've opposed this, and I wanted to listen to them. And so I had a fascinating series of conversations with large and small business leaders alike from around the world. They consistently supported their laws that were on the books and part of their social fabric. I asked them if they would repeal these laws if they had an opportunity to do so. They said no. A few said hell no. Why? Because they understood that these provisions enabled them to reduce attrition, to keep their valuable employees. And the cost of attrition is very high for employers. It was also a very important tool for the retention of women, because women, as you correctly point out, are primarily the caregivers. And if you look at the United States, the labor force participation rate of women went down during the pandemic because they are caregivers. So I would say to you, we are the only industrialized nation on the planet without some form of paid leave, but we're not the only industrialized nation on the planet with smaller businesses. We can do this, we must do this, and I've seen around the world that it works. And I thank you for allowing me to offer that perspective.
Thank you, Secretary Perez. Delia Walker.
Thank you to the sponsors. I'm just trying to get caught up on what this is. As you all know, I'm fairly new to this committee. So what other states are doing this right now? Are there other states that are doing this?
Yes, and I have it over here, Delegate Walker.
It was good. I was looking for it in the fiscal note.
Including, and I should say, including the District of Columbia.
Just a couple.
I don't have it in my testimony, but
Washington is one of them. I know that.
State of Washington. All right, and then for substance. So if I have a job where I'm making $100,000 a year, I put into this fund, how much will I receive in compensation once I guess, like file my claim or become eligible for this?
So if I may, Delegate Walker, and who is chairing? Is it Chairman Wilson or Vice Chairman Crosby? The panelists that I explained, one of them is the numbers person. And so I would like to defer her because I gave you an example of a sliding scale range, but you're asking for specifics numbers.
Yeah,
so I would like to.
I just use a round figure, 100,000. Yep.
So Delegate Walker, why don't we do this? We'll call the panel, then I'll come back to you for the questions. Real quick, just quickly Googling states that offer it. California, District of Columbia, Massachusetts, Minnesota, Rhode Island, Vermont, or some of the other ones. So let me call the panel, then I'll go back to you for the numbers because there is a numbers person. First up, Reagan Vaughn.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Regan Vaughn. I'm the Director of Advocacy for Catholic Charities of Baltimore and a member of the Time to Care Coalition. I'm here today in strong support of both HB 8 and HB 496. The sponsors both did an excellent job outlining the program, and I'm happy to take any questions on the specifics of the bill. But with my 2 minutes, I'd like to focus on why this bill is important, on who it's going to help. For almost 100 years, Catholic Charities of Baltimore has served Marylanders across Central and Western Maryland in a variety of programs. Enactment of this bill would be a game changer for all of our client populations. This bill would help the senior whose children want to move her from her apartment into an assisted living facility because they don't have the ability to care for her if she falls again. The bill would help the mom who had to hide in a storage closet while at work to participate in family therapy for her child who was hospitalized for psychiatric reasons. This bill would have helped the new dad who had to report to work while his premature baby was in the NICU and his wife was home recovering while dealing with a 2-year-old. This bill would help the small business owner who feels helpless to financially support an employee who needs to take time during her battle with cancer. And this bill would help the employee who's having an awful year, who after recovering from her own health emergency, had to assume caregiving responsibilities for a parent with a terminal illness. This bill, frankly, is designed to help all of us. Now you're going to hear from the opponents about administrative burden and costs, and those are legitimate points for discussion. However, it's this committee's role to balance those administrative concerns against the vast amount of testimony you're going to hear today, outlining the benefits for children, for families, for employees, for employers, for public health, and for Maryland's economy. I would urge a favorable report. Thank you.
Thank you, Ms. Vaughn. Next, we have Molly Williamson.
Thank you. Thank you to the chair, the vice chair, Delegate Valderrama, and the whole committee for the opportunity to testify today. My name is Molly Weston Williamson, and I'm Director of Paid Leave and Future of Work for a Better Balance, a national legal advocacy organization that fights for the ability of working people to care for themselves and their families without sacrificing their economic security. To that end, we have been working on paid family and medical leave in states across the country, including Maryland, for over a decade. We are delighted that Maryland is considering this important issue and proud to support both of these pieces of critical legislation. The need for paid leave has never been more urgent. Nationwide, the lack of paid leave costs U.S. workers and their families $22.5 billion each year in lost wages alone. When the COVID-19 pandemic hit, states that already had paid leave programs in place did better, while workers in states without these protections struggled because of their absence, compromising the effectiveness of our pandemic response. As we move forward, paid family and medical leave will help ensure workers can take the time they need to address their own or a loved one's COVID-related needs in the years to come. At the same time, paid leave, like what these bills would provide, responds to long-standing needs with profound and demonstrated health and economic benefits. To date, 9 states and the District of Columbia have passed paid family and medical leave laws. Programs are already in place and providing benefits each day under 8 of these laws and are currently being implemented in the remaining 2. The bill before you today builds on the successful time-tested models from these states, which have amply demonstrated how paid leave programs can benefit workers, businesses, the economy, and our communities. The evidence shows that a paid leave program like the ones under consideration here today can do the same for Maryland. You can find additional information about existing state programs in our written testimony, or I'd be happy to answer any questions you may have about these programs. Thank you for this opportunity. We urge a favorable recommendation on both pieces of legislation and look forward to continuing to work with you to make paid leave a reality for Maryland.
Thank you. Next up, I have Kaylee Schumitz, and I really hope you're the numbers person.
Yes, thank you, Mr. Vice Chair, and thank you to Chairman Wilson and Delegate Valderrama for introducing these important bills. My name is Callie Schumitz. I'm with the Maryland Center on Economic Policy, and we are a nonprofit, nonpartisan research organization focused on state fiscal and economic policy. We believe all Marylanders to be able to achieve their full potential in a healthy economy that offers a widely shared and rising standard of living, and enacting paid family and medical leave through HB 8 or HB 496 would be a major step towards realizing that goal. To put it simply, it's good for people, it's good for businesses, and that will translate to broader economic benefits. The majority of working people in the US, including Maryland, do not have paid leave that they can use to take care of the kinds of family needs we will all experience at some point in our lives. Research shows that the two main reasons people don't take this unpaid leave are not being able to afford it and concerns about job security, both of which this bill addresses. The lack of paid leave creates great hardship for families and has significant societal costs that the Time to Care Act could help reverse, as other speakers will address. Right now, the responsibility for providing paid family and medical leave falls solely on businesses, and especially for small businesses, it's often not affordable for them, even if the business owner wants to provide leave to their employees. By creating the shared public insurance pool as outlined in the Time to Care Act, the cost for any one person or business is very modest, and workers' ability to take a meaningful amount of paid leave is no longer dependent on their employer's ability or willingness to provide it. Surveys conducted in states that have family and medical leave programs show that the programs either don't affect their bottom line or have a positive impact. The biggest cost savings for businesses is reduced turnover, as peer-reviewed studies show that having paid leave makes people more likely to return to their job. And as we see with our safety net programs, it's also generally better for businesses when families are more financially stable because they have more money to spend at the businesses in their community. So we had asked for a favorable report on House Bill 8 and House Bill 496. And as noted, the Maryland Center on Economic Policy has done analysis on the various impacts of the bill, and happy to answer any questions if I can briefly address the delegate's question now, or we can come back.
Yeah, I mean, Delegate Walker already asked the question, so if you could just touch on the math, and then
sure.
If he has any follow-ups, I'll give him the floor first.
Okay. Yes, so I believe Delegate Walker was asking about the benefits that someone would receive if they earned $100,000 a year. So the kind of similar to unemployment insurance, it is progressive wage replacement. So people with lower incomes get a greater share of their income as a benefit. And then there's a maximum benefit of $1,000. So someone who was earning $100,000 a year would receive the maximum benefit. That's $1,000 a week for up to 12 weeks.
So it's $1,000 a week. Okay, I got confused by the fiscal note. So they can earn
Yeah, and there's a
$1,000 per
chart
week.
attached to our testimony, our written testimony, that
Sure.
could help visualize it.
All right, $1,000 per week, maximum of 12 weeks, right? So we're talking $12,000 would be what they would cap out at if they made $100,000.
Yes.
Okay, and then I guess this would go to the sponsors, or one of the sponsors, Delegate Balderrama, or to Chair Wilson. So over the years, I know I've seen who qualifies for this. Like, I know we had a discussion, I can't remember if it was in this committee or Ways and Means, where they're like, if somebody's passed away, they would qualify for this. That wouldn't qualify for this, right? If we were to change some of the things, or what are some of the qualifications somebody has to have in order to
It's
qualify?
to ail, like a pregnancy, an adoption, to ail for an ailing family member, a military person. There were several examples. I don't know if I mentioned in this testimony, I've given it 4 years in a row now, but those are the examples.
All right, well, thank you.
Thank you, Delegate Charkoudian.
Thank you, Mr. Chair. My question, I've been reviewing some of the opposition, and I'm just wondering if I could get any of the three of you to speak to some of the issues. Either Molly, possibly, you said you've looked at other states or worked with other states. Kaylee, I'm interested in the sort of economic analysis. You talked about the peer-reviewed studies. And so it makes sense to me. I think you said the peer-reviewed study shows that this increases the retention of employees. Is that what you said, Kelly? Did I get that right?
Yes.
Okay, so that makes intuitive sense. And as an employer, a small organization, it certainly is something that we've struggled with, and I would welcome having this, and I could see how it can make that difference. Can you talk about some of the other issues that I think we're going to hear about are related to how the replacement, has there been any studies on how folks find replacement during the period of time that that someone is on leave?
Sure, I'm happy to speak to that, or Keely, if you'd prefer to.
Go ahead.
Yeah. So there is, for example, research out of Rhode Island, which finds that basically employers figure it out. So employers faced with a worker who is taking leave, depending on the particular situation, may decide to hire a temporary replacement worker. Often you can just provide additional hours to workers who are there. Sometimes you move around projects. So you decide, okay, the really key point person is not here. We're gonna move around the order in which we do things in the way that employers are already doing right now. So in so many of the situations that we're talking about, workers are going to end up needing the leave, whether there's a paid benefit available or not. So for example, if you are seriously ill and physically can't work, you're going to need to take that leave, whether it's covered or not. So employers are already experiencing this each and every day. But what the paid leave program changes is we're giving employers a new tool to respond to that, because since the paid leave program is paying the worker their benefit while they're on leave, the employer still has all the money in their bank account that they were otherwise going to pay in salary or wages to the employee who's now on leave. And the employer gets to use that tool in whatever way the employer thinks makes the most sense to help bridge that gap.
Okay, thank you. That's really helpful. And I guess I'll just ask one other question and follow up in emails for others. But I think because it looks like there's sort of fear of the unknown, which is common in the opposition when we're considering making a change. And so I just wanted to give you another opportunity if there's any other research that has been done on, in addition to the research that shows the benefits to sort of the health of the employees and families and retention, any other research that highlights the benefits to the businesses and the economy of the state that has made these changes.
Sure, I'm happy to speak to that, or Keely, would you prefer to?
Go ahead.
So I think in addition to that research on retention, and that Keely pointed to, which I think really does go to, especially now we know employers want to keep high quality employees. You want to be able to keep people that you've invested in around, and this is a tool to help you do that. What we've also seen is, for example, research out of California, which found that after California implemented a paid family leave program, they did a very large survey of employers, including small employers, and found that on a whole bunch of axes, employers reported that even though there'd been all of these same concerns about impact on productivity, about fraud, that what employers found over and over again is that employers said that there were either positive or neutral impacts by overwhelming margins on things like productivity, on things like worker retention, on things like profitability. When you ask employers, similarly in Rhode Island, even though, again, you heard these same kinds of opposition arguments about concerns about business impact, when you surveyed Rhode Island small businesses a year after the program went into effect, a majority supported the program. So I think that what we've seen is there is this fear of the unknown, but once the program gets implemented, employers across the country have seen that it's really no big deal and really see the benefits that it can provide to them. And that goes to the broader economic benefits too. So as I alluded to, essentially right now, Maryland is already paying for the lack of these benefits. They're paying for it in people who have to leave the workforce because of their health or caregiving needs and therefore aren't paying in taxes. They're paying for it in folks who need to use public benefits that they wouldn't need to use if they were able to keep their job and keep their income. They're paying for it in increased healthcare costs from people who can't get the healthcare they need. They're paying for it in more people who need to, as Regan spoke about, need to take additional care that they wouldn't need if a family member could care for them. So I think this is really an opportunity to say, we're going to pay for the smart. We're going to make a small and sustainable investment in providing the protections that workers need and the benefits workers need in a way that works for both workers and employers, and that meets the needs of workers, employers, and the economy.
That's great, thank you. And if do you mind just sharing some of those studies with the committee, because I think it helps kind of create reassurance of the concern about like what this transition could look like.
Yes, absolutely. And I'll say, I think all the stuff I mentioned is already cited in my written testimony, but I'm happy to follow up as well.
Fantastic. Thank you so much.
Delegate Aaron's, you had your hand up. You good?
Yeah, I just had one quick one now. What is the maximum amount of paid leave a person can get now based on this bill? But that could go to Ms. Williamson if she wants.
I'm happy to speak to that. So this is also a place where both bills are the same, which is helpful. So typically under this bill, workers are only going to be able to take 12 weeks per year. So if you have just one health need, under very particular circumstances, if a worker has first their own serious health need and then a family leave, they may be able to take more than that. But typically it's going to be about 12 weeks. And what we've seen from other states, and I think this is actually reflected in the fiscal notice.
I guess effectively, I can have 3 months off a year based on this bill and paid leave, 3 months off every year.
If you had in that year a
you
serious
could.
health need, a family member with a serious health need,
So,
a new child. So if you have those circumstances, but most people aren't going to have those circumstances every year.
I don't know that we know that or not, but the maximum, so 3 months out of a year, I may potentially don't have to work because I have a circumstance. Thank you very much.
Okay. Paula Molina Acosta.
Hello, can you all hear me?
We got you.
Cool. Good afternoon, everyone. I am speaking in favor of the Time to Care Act of 2022. I am Paula Molina Costa, and I've lived in Maryland for most of my life, and I'm representing the National Partnership for Women and Families, which is an advocacy organization working to achieve equity for all women. So at the very center of our mission is addressing the crisis that leaves just 23% of workers with access to paid family leave. As a society, we've chosen to let the vast majority of us, face a terrible choice between economic stability and the needs of our families or even our own health. Over the last 2 decades, the National Partnership has helped states develop paid leave programs that have strengthened families, businesses, the economy, and public health. In short, these state programs have proven that paid leave works. It's affordable for workers and employers, and it's fiscally sound. Research highlights substantial benefits for families' well-being and economic security and stability, including a reduced need for public safety net aid. Unlike private plans, a public program covers the most vulnerable workers and those most needing support. All of the state paid leave programs have proven to be financially stable. Despite their fears, once paid leave programs are implemented, businesses have faced minimal burdens while citing benefits to employee morale, productivity, and turnover rates. It's particularly helped small businesses to be able to offer benefits that allow them to compete with larger corporations. In these states, paid leave is immensely popular among voters of all stripes. And this is why states who have implemented paid leave have been doubling down by expanding access, increasing benefits, and extending the duration of leave. We thank the committee for considering a paid leave program, and we look forward to helping in any way that we can. Thanks.
Thank you. Monica Roberts.
Good afternoon. My name is Monica Roberts, and I am testifying on behalf of myself and my fellow members at SEIU Local 500. SEIU Local 500 represents over 20,000 working people in the region, including support staff at Montgomery County Public Schools, family child care providers, faculty and staff at institutions of higher learning, staff at nonprofits, and many other working people across the region. As a school administrative secretary at NCPS, I'm here today to share with you my support and SEIU's support of House Bill 8 and House Bill 496, the Time to Care Act, from my perspective as a mother, a union member, and a senior citizen. SEIU 500 thanks Chairman Wilson, Delegates Valderrama, and Kelly for their leadership on this important issue. 6 years ago, I became ill and required life-saving surgery along with a difficult recovery period. I can testify to how important it is to be able to have your child or loved one be able to take the time from work to take care of you. My daughter, Patty, was with me every step of the way. She was able to stay at home and take care of me, as well as sit at the hospital and take me back and forth to doctor appointments. She did this regardless of the financial burden or the strain it put on her family. She did this because I am her mother, and that was the end of that. In 2018, complications from the surgery before became another life-saving event. By this time, I had retired and was living on a very tight retiree budget. I was concerned about co-pays, hospital stays, my daily cost of living. My daughter, Patty, was with me again. I was again, as before, concerned over the time I was taking her away from work, the threat to her family and her family's financial state. She spent so much time driving me back and forth to doctors, sitting at hospitals, and just the extreme weight of the situation we were in opened the door for worry. The freedom or ability to put the financial expense to the side and be able to be there for the family member in need is sometimes all a person can handle. To be honest, I was concerned about sharing my story with you. I was concerned if you would really listen and understand what I was telling you about my story. Thinking about my future health and the possibility of another health crisis, I find myself extremely scared, assessing the specifics. A child who wants to take care of her mother, but the financial burden to do so is not only frightening, but lends itself to a feeling of helplessness. What if I become so ill where I need help around the clock? How can I ask my daughter to take time from her work and put that financial burden on her to take care of me when she already has a family? No Marylander should ever have to choose between a paycheck and caring for a family member. The issue is that when a family goes through a health crisis, it is not only just for the person who is ill. It is also a crisis for the family who wants to provide the much needed support and resources. It is a family crisis. Passing the Time to Care Act would provide the support and resources at the time when the family needs it the most. SEIU Local 500 respectfully requests that you support HB 496 and HB 8 and strongly urge a favorable committee report. Thank you very much.
Thank you. And just for everybody's awareness, we have about a little over 30 witnesses left to testify between these two bills. So just making sure everybody adheres to the 2-minute time standard. Next up, we have Tracy Guy Decker.
Hello, good afternoon. Thank you so much for the opportunity to speak with you today. As mentioned, my name is Tracy Guy Decker. I am a resident of Baltimore City in the 41st District. And today I speak to you as the wife of a recently retired Navy chief. So I did provide written testimony where you can read about my experience as a Navy wife when my husband received orders unaccompanied, that is without me or our daughter, to Manama, Bahrain in late 2019, and why I think a version of the Time to Care Act is essential for military families. But I'd like to use what's left of my 2 minutes to speak a little bit more about what military families face and why you probably aren't hearing from too many of us. The truth is that I am not a typical military spouse. Military families don't usually get involved in local or state politics because when your partner's employer forces you to relocate approximately every 3 years, local politics takes a back seat to finding work for yourself, schools for your kids, doctors, dentists, mechanics, veterinarians, et cetera, et cetera, et cetera. As a Baltimore native, I was lucky enough to have had my active duty spouse stationed at Fort Meade for most of the time that we have been married. I say lucky because unlike most of my counterparts, when my service member received overseas orders for a year, I was able to lean on my mom, other existing relationships for the logistical and emotional supports one needs in such situations. When my husband's former shipmates are deployed, their spouses rarely have local family. And because they are often working either low-skill, low-benefit jobs like customer service or retail, or high-skill, high-stress jobs like healthcare, they don't always have the luxury of paid time off to prepare for and manage their service members' deployment, or God forbid, the return of an injured or traumatized service member. I see that I am running out of time. I just want to say that most of them are not paying attention to what you all are doing because they are managing burdens that would pull many of us under. They deserve help on everything, and HB 8 or 496 would help mitigate that whole. I urge a favorable report. Thank you.
This is Guy Decker. Thank you so much for the testimony. And I think I speak for all the veterans on the committee, including myself. I just want to thank you for your service because when, the service member goes to war, a lot of people don't realize the whole family goes to war. And it's not easy to be left behind. And in fact, I think it's harder for the families that have to stay stateside. So thank you. Delia Rogers.
Thank you.
Mr. Vice Chair, you took the words out of my mouth. I just wanted to thank Ms. Guy Decker for her testimony as a military retiree and a military spouse. Thank you for your service. And again, to what Delegate Crosby said, me too.
Okay, Laura Wheeldryer.
Hi, thank you. Good afternoon, Chair Wilson, Vice Chair Crosby, and honorable committee members. Thank you for the opportunity to testify today. I'm Laura Wheeldryer, Executive Director of Maryland Family Network. We're a statewide nonprofit and leading voice in early childhood. And today I'm here to urge your favorable report for both HB 8 and HB 496. You've already heard it said, but I'm going to say it again. It doesn't matter your age, race, what region of the state you live in, or your political party. Marylanders agree that paid family and medical leave is a good idea for our state. The last 2 years have shined a light on how fragile the social structure of this country is and how much the family unit as the fundamental building block of our society is crying out for attention. Whether your concern is racial and gender justice, the strength of families, the work revolution, and the economic threats which we are all currently living through, or the healthy development of our future generations, paid family and medical leave is a policy that helps to address all of these issues. Maryland Family Network plays a statewide role in speaking on behalf of babies, their parents, and their caretakers. Our constituents need paid family and medical leave. Marylanders face an untenable choice between the families that they love and the jobs that they need. If you need me to, I am happy to run through a vast array of public health research about the benefits of time together for babies, for moms, for dads in those weeks and months after a birth or an adoption. This is our chance to do what is right, what is needed, and what the voters are asking for. Our state needs your bold leadership now. This is your chance to be a caregiver for the state of Maryland and vote to support Time to Care. Thank you.
Thank you, ma'am. Joseph Vogel. All right, I do not see Mr. Vogel in the waiting room. We will go to Philemon Kenzariski.
Thank you, Vice Chair Crosby, Chair Wilson, and Delegate Valderrama for introducing this legislation. My name is Philemon Kenzariski here on behalf of the American Council of Life Insurers and the League of Life and Health Insurers. Helping workers care for their families and themselves is one of the most critical missions of life and health insurers in Maryland. And the COVID-19 pandemic has only further highlighted the need for a paid family and medical leave program. Life insurers provide paid family medical leave options to employers and support private sector solutions across the country. And the benefits provided through employer-insurer partnerships are vital to the health of workers and the financial security of their families. Workers shouldn't be penalized for taking time off to care for their families when needed. ACLI and the League members believe that we must work to find viable solutions that meet this fundamental need across Maryland. We thank all the sponsors for including our suggested language that allows proactive companies that exceed the parameters of the paid family leave program as proposed to continue to care for their employees in an appropriate manner. And with that, we just like to reiterate our support for paid family and medical leave. Thank you.
Thank you, sir. Margot Quinlan.
Yes, thank you. Chair, Vice Chair, members of the committee. My name is Margot Quinlan with the Mental Health Association of Maryland. I hope folks can hear me. I'm camping out in the hallways like a lot of us. I know there's a long night ahead of you, and so I will be quick, but we are really eager to lift up the intersections of paid family and medical leave and behavioral health. We know that 1 in 5 Americans will experience a mental illness in a given year, and 1 in 5 children are either currently or at some point during their life have had a serious debilitating mental illness. The COVID-19 pandemic has only further taxed the mental and behavioral health of many Marylanders. 40% of Marylanders report having experienced anxiety or depression as a result of the pandemic, and Black and Brown communities have endured disproportionately higher rates of job loss due to COVID-19. Allowing Maryland workers time to care for themselves and their families during long-term mental or behavioral health treatment or recovery is absolutely critical to supporting a strong economy. At a time when our national economy is still weathering one of the worst public health crises of a generation, it is increasingly critical that we support a healthy and sustainable Maryland workforce. And for these reasons, the Mental Health Association of Maryland supports the Time to Care Act and urges a favorable report. Thank you so much.
Thank you, Michelle Siri.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Michelle Siri. I'm the Executive Director of the Women's Law Center of Maryland. It's been an honor to support this bill since its introduction. I'd like to thank Delegate Valderrama for continuing to champion this issue and to Chairman Wilson for his leadership today. I'm also here to tell you that the working women of this state are at a breaking point. We've been sounding the alarm for years. You know the statistics, 2/3 of women in Maryland being the sole primary or co-breadwinners for their families, while simultaneously bearing the brunt of the caregiving. But we've hit critical mass since the pandemic. In the She Session, it is still happening. It is still wreaking havoc on our families. So back in December of 2020, we saw an unprecedented number of women leave the workforce, with women accounting for all the net jobs lost in this country. The most recent jobs report for January 2022 was optimistic, but unfortunately not for women. That growth was all driven by men who have now recouped all of their job losses since the pandemic began, while women are still struggling to catch up. In fact, there are nearly 1.1 million fewer women in the workforce now compared to February of 2020. That's not surprising given everything that we know about women in the workforce. Everyone has heard about the need to shatter glass ceilings, but there's so many other barriers that exist, particularly for women in low wage position. Take the sticky floor, where women are being stuck and unable to progress in their position or salary because every time a life event happens, such as an ill partner or a parent passing, or in my case, the birth of a son, women continually put their careers on hold and get pushed back down the ladder of success. I experienced the sticky floor firsthand when I was taken off partnership track and denied bonuses for trying to juggle motherhood and my career. And then there's the leaky pipeline where women enter the workforce at the same rate as men, but as they progress in their career, they dwindle, being forced out of the workplace altogether due to competing work and caregiving demands. This is what we're seeing play out in real time as school and daycare closures are preventing women from returning to the workforce. And all of these scenarios can be addressed by implementing paid leave. For all those reasons and everything everyone else has said, I strongly urge a favorable report on HB 8 and HB 496. Thank you.
Thank you. Jeffrey Rubin.
Thank you, Vice Chair Crosby. My name is Jeffrey Rubin. I live in District 15, and I support both bills for the reasons outlined in my written testimony. I think it's important to recognize how households have changed in recent decades. The model of a man being the sole breadwinner and a woman remaining at home to clean house and to be the all-purpose caregiver is no longer common. Likewise, in many communities, it is no longer common for members of the extended family to live nearby. When serious illness strikes a family or a new child is welcomed into the home, dependable helping hands often are hard to come by. These bills address that reality. They're based on the premise that workers are people, not widgets. They have needs and responsibilities that on occasion will require them to take time off from work. When that happens, they will need some income to sustain them and reassurance that they will still have a job when the health crisis has subsided or the adjustments to a new child have been made. This legislation is not asking for taxpayers to foot the bill for the cost of its provisions. Instead, the parties most affected would share the cost. Employers and employees would each make a sacrifice. For a worker earning $15 per hour, depending on the bill, employers would have to pay into an insurance fund either less than 6 cents an hour or not more than 7.5 cents an hour. When workers take time off, employers would save the cost of that worker's salary and could choose to use those funds for temporary help or some overtime for coworkers. Workers would have to pay the same amount into the insurance fund and take a 10 to over 50% cut in their regular income when on leave. Shared sacrifice will instill shared loyalty. These plans are fair, and now is the time to make this happen. Thank you.
Thank you, sir. Claudia Remington.
Thank you, Mr. Vice Chair and distinguished members of the committee. My name is Claudia Remington. I'm the Executive Director of the State Council on Child Abuse and Neglect, or SCAN. SCAN is a multidisciplinary advisory body to the Governor and the General Assembly and advocates for policies that prevent and mitigate child maltreatment and other adverse childhood experience, or ACEs. We believe that investing in paid leave and other policies that support the healthy development of our children builds a strong foundation for kids and for society. I'll share 2 key reasons SCAN supports paid family leave. First, it has been shown to reduce the leading cause of fatal child maltreatment in young children, abusive head trauma. In research comparing California state with paid family leave and 7 without, paid family leave was linked with fewer cases of abusive head trauma in infants. During the Great Recession, abusive head trauma actually declined in California while rising in other states. Abusive head trauma is often associated with a parent's level of frustration and tension with the baby's incessant crying. Both infant crying and abusive head trauma peak at 6 to 8 weeks, so decreasing levels of parental stress during this time with policies such as paid family leave is extremely helpful. Actually, paid family leave has been linked to preventing other ACEs. In preventing ACEs, leveraging the best available evidence, the CDC identifies key policies policies known to prevent or reduce ACEs and their effects. Paid family leave is among them, as it strengthens economic supports for families and ensures a strong start for children. Research shows that parents facing financial hardship are more likely to experience stress, depression, and conflict in their relationships and family, all compromise parenting and increase the risk for violence and other ACEs. Paid family leave protects families from losing income to care for an infant or sick family member. It can prevent ACEs by both providing bonding time with an infant and reducing parental stress and depression due to economic concerns. Strengthening economic supports for families and ensuring strong starts for children are multi-generational strategies that address the needs of both parents and children, ensuring that families succeed and their children achieve lifelong health and well-being. For these reasons, SCAN urges a favorable report on HB 8 and HB 496. Thank you.
Thank you. Joe Schifrin.
Good afternoon, Mr. Chair. Mr. Vice Chair, the esteemed members of the committee, and Delegate Valderrama for introducing this bill. My name is Joe Schifrin. I live in District 16. I'm testifying in favor of both HB 8 and HB 496. I'm also testifying on behalf of Jews United for Justice, which organizes more than 6,000 Jews and allies across Maryland to help with social, racial, and economic justice campaigns. The lack of paid family and medical leave affected me twice in the past 25 years. In the late 1990s, my mother-in-law developed a number of medical problems. She was diagnosed with dementia and could not be left alone. Without PFML, I was forced to leave my full-time job and stay home to care for her. We were very fortunate that my husband's full-time job was able to cover all of our bills, but I am acutely aware of all the others that are forced to choose between working to pay their bills and staying home to care for a loved one. 15 years later, I was diagnosed with breast cancer. During chemotherapy, I was too sick to work most of the time. While dealing with my cancer, I learned about a neighbor, a single mother who had the same diagnosis. But without support, she continued working with no opportunity to rest and recover. A few months later, when I was ready to return to work, I learned that she had died. I often think of how things would have been different for her family if there had been a paid family and medical leave program. Passing HB 8 and HB 496 in their strongest form would help address these issues for workers across Maryland. Speaking both for myself and for Jews United for Justice, we urge a favorable report on HB 8 and HB 496. Thank you.
Thank you, and we appreciate you sharing your personal story. Next, Matt Peterson.
Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. My name is Matt Peterson. I'm here on behalf of the Baltimore Jewish Council in strong support of HB 8 and HB 496. We're proud members of the Time to Care Coalition, the Maryland Senior Citizens Action Network, and we join a broad coalition of faith communities and faith leaders from across Maryland to say that it is absolutely time that we pass paid leave in our state. Everyone gets sick. We know that. We've heard plenty of stories. And we're all at some point going to have to take care of a loved one, or we'll need to take time off to care for ourselves for any reason. And we know that this is an issue that has received wide support among voters in Maryland. Upwards of 80% of voters agree that we need paid leave in our state. And as leaders in the Jewish community, we believe that we need to be taking care of ourselves. People need time to address health. Health and longevity is the most important thing in the Jewish faith. And we absolutely believe that this policy will help support that. So again, we're here in support of HB 8 and HB 496, and we urge a favorable report of both of those bills. So thank you for your time.
Thank you, sir. Rebecca Coppola.
Hi, thanks. Thank you for having me here today. I'm Rebecca Coppola, an 1199 SEIU member and family nurse practitioner in Baltimore. I'm honored to be testifying about this critical bill, HB 8, to provide my patients and fellow Marylanders paid family and medical leave. We have the opportunity with this bill to do a great good for new families and families facing serious illness. These are situations we all face at some point in our lives, and helping people through times of great change or crisis benefits everyone, from patients and employees to employers in the state. Too often, we face impossible choices when we have a baby or a health issue in the family. Do you follow medical advice, stay home, heal, and take care of a loved one? Or do you go back to work and risk compounded health issues or permanent disability? This difficult choice hurts people, families, and communities. Marylanders and their families lose their paycheck, maybe their life savings if they follow the doctor's orders, or they go back to work for that needed paycheck and suffer so they can pay the bills. Health conditions worsen, making treatment more painful and more expensive down the line. Working while sick or injured, or while staying up late every night caring for a loved one is hard. That's especially the case for many of the essential workers that currently lack paid family and medical leave, such as most healthcare workers, grocery store workers, bus drivers, etc. Regardless of profession or background, no one in our state should have to make these hard choices. No mom should be going back to work with a 3-week-old at home in order to make ends meet. And that's why I respectfully urge a favorable report on paid family and medical leave legislation. By ensuring all Marylanders can have paid family and medical leave, you can help people take care of their families and have kids without having to forego groceries. You can help my patients to be able to heal and return to work when they're ready, not just when they have to make rent. You can help kids have a brighter future, make our communities healthier, and our state stronger. Thank you.
Thank you. Caleb Jasso.
Yes, thank you. Good afternoon. Thank you to you, Mr. Chairman, members of the committee for your time. Caleb Jasso, policy advocate with the Job Opportunities Task Force, an independent nonprofit organization that advocates for better jobs, skill training, and wages for low-income workers and job seekers in Maryland. JOTF strongly supports House Bill 8 as a means to ensure that hardworking Marylanders can take family and medical leave without having to risk their job, paycheck, or financial security. We've heard a lot of very moving, important, data-driven testimony today, so I will keep this brief. As the legislation currently stands with leave, the unpaid nature of it disproportionately impacts low-wage workers and/or those especially who work in small businesses, as they are even more likely to not receive paid family leave, as well as to not take leave due to the possibility of losing out on those important paychecks. This lack of paid family and medical leave drives families below the poverty level. Too often, the pay gap that occurs when a new mother must take unpaid leave after giving birth, combined with the increasing expenses of childcare, sets back families for years. The benefits of paid family leave and medical leave would be largest for those with limited education and lower incomes, as these workers currently have the lowest levels of access to any form of leave, paid or unpaid. We urge a favorable report of House Bill 8, as it would ensure that millions of hardworking Marylanders, in particular low-income workers, who are at least able to lose even a single paycheck, are able to take necessary time off for their family and medical life events without the risk of falling into poverty. Thank you very much.
Thank you, Kenneth Capone.
Good afternoon, committee members. My name is Ken Capone. I am the Director for People on the Go, which is Maryland's statewide self-advocacy organization. We are here to testify in support of HB 8 and HB 496 Labor and Employment, Family and Medical Leave Insurance Program. People on the Go Maryland builds community through diversity and inclusion. Our beliefs in empowerment and inclusion provide the means by which people with intellectual and/or developmental disabilities come together to develop self-advocacy and leadership skills and give voice to the needs of the disability community. As many of you are probably aware, nearly all of us will need to take leave at some point, whether to care for family members or our own serious medical condition or disability, or the joyous occasion of welcoming a new child. Without access to paid leave, workers often face a difficult and unnecessary decision: health and family, or work and making ends meet. Not now, but in the past, my mother had to take off work to care for me if I got sick or my support needs intensify, or even longer when I had surgery. I know it was a hardship for us. It would have been nice to have something like this back then. More than 70% of family members caring for a person with intellectual and/or developmental disabilities report that caregiving interfered with their work, and the odds of an employee losing income increases by 38% if the person lives with a child with disabilities, and by 29% if the person lives with and supports an adult with disabilities. That is a significant amount of people experiencing economic hardship. When people having access to dedicated paid family leave, it reduces the odds of losing income by 30%. As more people with intellectual and/or developmental disabilities are supported to work, these additional benefits are important. People with disabilities need leave for the same reasons as all other workers, and in the U.S., addressing one's own health condition or disability makes up 55% of all leave taken. People with disabilities are more likely to be employed in low-wage, part-time jobs that provide fewer supports. Access to paid leave increases opportunities for people with disabilities so that we can be supported when needs intensify, just like I did from time to time. The benefits to people with disabilities and their families are clear. Both the person that is sick and the person that is caring for them have time they need to be together and get or give support. They will be less stressed, which in turn speeds up the healing process. In conclusion, HB 8 and HB 496 gives people with disabilities the comfort of knowing that they shouldn't feel guilty anymore because they may need extra care from a family member from time to time, and it won't be a hardship on the family. Thank you.
Thank you, sir. Next, we have Tammy Bresnahan.
Hi, good afternoon, Mr. Chair and Mr. Vice Chair. My name is Tammy Bresnahan. I am the Director of Advocacy for AARP Maryland. You've heard from over 20 witnesses. I can't add any more to them. We thank Delegate Valderrama and the Chair Wilson for putting these bills forward. We've supported them. We're a member of the Time to Care Coalition. I have 3 pages of testimony for your perusal. We urge a favorable report. Thank you.
Thank you, Tammy. Next, Nora Carlos. Do not see that individual in the waiting room. However, I do see Christopher Dews.
Fantastic. Members of the committee, my name is Christopher Dews, Senior Policy Advocate of the Job Opportunities Task Force. Our mission is always to help low-wage workers advance to higher wage jobs. We have a history of supporting this piece of legislation because it's good and it works. Very, very briefly, I know my colleague, Caleb Josso, our newest policy advocate, spoke very strongly on this already, so I'll not repeat anything that he or anybody else has said. Just a personal story. As we were doing I was doing my personal research on this, I discovered that this issue is a lot closer to home than I thought. In 1987, when my oldest brother was born, FMLA wasn't even in existence. So my mother had to give my brother up on her first day back to work. And of course, she cried the entire way to the office. And of course, that wasn't a very good day at work. 4 years later, she had worked at that company and built up a reputation for herself and was able to take off paid leave for a good 12 weeks. And it was a beautiful thing for her. But of course, she was a top performer. The bottom line is that this is necessary specifically for working mothers. And another thing I didn't even notice when I was much, much younger is that when my grandmother was very, very much ill and she was moving towards, a terminal situation, my mother, I thought that she had taken off of work because she had retired intentionally, but that's not at all what happened. She did not have access to the necessary paid leave to be able to take care of her aging mother. So for those reasons, we need this bill. We need it to move. We need it to move very quickly. And I want to thank you all for taking the time to listen.
Thank you, sir. Next, we have Ruth Martin.
Good afternoon. Thank you, Chair Wilson, Vice Chair Crosby, and members of the Economic Matters Committee for holding this important hearing on the need for paid family and medical leave. On behalf of Moms Rising's over 30,000 Maryland members from across the state, we urge a favorable report on both paid leave bills. My name is Ruth Martin. I'm the Senior Vice President of Workplace Justice Programs at Moms Rising, a national organization fighting for women and families and economic security, including a national paid family and medical leave program that would set a minimum floor across the country. I'm also a Marylander from District 20. I live and work and raise my family in Silver Spring. I also served on the paid leave task force referenced earlier, and am additionally on the board of the Maryland Legislative Agenda for Women, and also supports the Time to Care Act. It's clear we need a national paid leave program in this country, but it is also imperative that Maryland pass paid leave and do it as soon as possible. Paid leave is good for our economy. It keeps people attached to the workforce. It's good public health, and it's good for our family's economic security. It's also clear that sadly, at the moment, paid leave has become part of a political issue at the federal level and on Capitol Hill, and has stalled out, as has the larger Build Back Better program. So while Congress continues to figure out how to move forward these critical issues, Maryland can and should act now. As you've heard, 9 other states have already passed paid leave laws, and many with bipartisan support. Not surprising, paid leave is a nonpartisan issue and enjoys enormous support from voters regardless of party affiliation. So while it is important that we pass the national minimum standard, the truth is it might be a little ways off. And in the meantime, those of you at the state level who really have your fingers on the pulse of what your constituents need can and should act now. For these reasons, we urge a favorable report on both bills. Thank you.
Thank you. Kayla Mock.
Good afternoon. I feel like I just hit the lottery. Chairman Wilson, Vice Chair Crosby, and members of the Economic Matters Committee. My name is Kayla Mock. I'm with the United Food and Commercial Workers Union Local 400, and we represent over 10,000 members on the front lines of this ongoing pandemic in grocery, retail, food processing and distribution, law enforcement, and healthcare. We're also here as proud members of the Time to Care Coalition. For all the reasons stated before me, and for every Marylander who has been forced to choose between going to work to provide for their families or staying home to care for their families or themselves, we strongly support HB 8 and HB 496, and we appreciate the patrons bringing these bills forward. Thank you.
Thank you, Ms. Mock. Now we'll go to the additional favorable witnesses on House Bill 496. First, we have Matt Weaver.
Hello, Chairman Wilson, the rest of the committee. I apologize, my video isn't working. My name is Matthew Weaver. I'm a resident of District 45, and I'm submitting this testimony in support of HB 496, the Time to Care Act. 3 years ago, I was diagnosed with ulcerative colitis. I tried to work through my condition, but eventually I was unable to. My 7-year-old father tried to support me as much as he could, along with friends and family. They all did their best to keep me above water. But eventually it ended up becoming too much, and I was evicted from 2 apartments. Me and my son were both kicked out of 2 apartments and racked up a significant amount of debt. I eventually had life-saving surgery and was able to heal a bit and got a new job with Zeke's Coffee. Zeke's has a roastery over in Hamilton and Laurelville area, along with the cafe, and I just opened a new cafe for them in Pigtown. Me and my boss, in fact, today just had a conversation because I need to have another surgery in the summer about what I was going to do. We're not really too sure about how we're going to handle this. He wants to support me as much as he can, but if we had something like this bill already enacted, we wouldn't have to have this difficult conversation. So I truly respectfully urge the committee to return a favorable report on HB 496. Thank you very much.
Thank you. Jared Hawkins. I do not see Mr. Hawkins. Kevin Lindemood.
Yes, good afternoon, Vice Chair Crosby and members of the committee. Thank you, Chairman Wilson and Delegate Valderrama, for your leadership. My name is Kevin Lindemood. I'm the President and CEO of Healthcare for the Homeless. We're Maryland's leading provider of integrated healthcare services and supportive housing for men, women, and children experiencing homelessness. We served more than 11,000 different people last year. We are committed to supporting our staff as whole people, and we strongly support these bills. As a nonprofit business of 250 employees, we have long offered paid time off, paid parental leave, and we are always looking for ways to provide even greater family and medical leave as envisioned by these bills. All healthy businesses, for-profit and non, need a sustained workforce over the long term, and this involves frequent changes in life circumstances. Now, you will hear from employers who claim that establishing paid family and medical leave would negatively impact their bottom line. We've heard these same unfounded fears before. Take, for instance, the fight to raise the minimum wage. We've long indexed our wage floor to the local cost of housing. Currently, no one at Healthcare for the Homeless makes less than $17 an hour. And when we established this wage floor 20 years ago, people told us we'd go out of business. We didn't. We've grown every year. Similarly, offering our employees benefits like paid time off and paid parental leave improves retention, satisfaction, and longevity. You may also hear unfunded alarm that people will suddenly claim a benefit they're not eligible for. And in our experience, this just isn't true. There are rules for documentation and approval. People use it like insurance. They take it when they need it. If a pandemic, in closing, has taught us anything, it's that we're all human and vulnerable, and that the line between the professional and the personal is a thin one. We'd have a hard time recruiting staff if we didn't offer robust benefits. We strongly stand behind these bills and urge a favorable report.
Thank you, Nikki Tyree.
Good afternoon. My name is Nikki Tyree, the Executive Director for League of Women Voters of Maryland. I won't spend time reiterating what a lot has been said, so I will say that the League stands behind our 100-year positions and consensus process that says that the government should come to the aid of all citizens to help facilitate equitable living conditions and reduce poverty as much as possible. This bill, paid family leave, would give families experiencing the birth of a child or adoption or an unexpected illness the ability to not plunge into poverty. And for that, we would be very grateful. The League thanks you for urging a favorable report.
Thank you. The next two people I don't see in here, but I will call them. And if they are on, if they could just correct their name. May Anna Hassel. And the second is Josie Rhodes. Okay. That concludes all the favorable. We'll now go to unfavorable. Paul Fry.
Good afternoon, Mr. Vice Chair, Mr. Chair, and members of the committee. Paul Fry, President and CEO of Washington County Chamber of Commerce, representing 575 member organizations with over 40,000 employees. First, Delegate Valderrama, my sincere condolences regarding your mom. I too have been with my parents, in-laws during their later years, and it's certainly an emotional time for children, so my condolences. With that said, respectfully, we're opposing both House Bill 8 and 496 for the reasons outlined in my written testimony, in addition to the following concerns. The bill's fiscal notes include $21 million to implement and administer the program annually, and whether or not it's forward funded, someone has to pay for it, and this includes hiring over 80 employees. The cost to municipalities and state government all will impact taxpayers in Maryland. The impact in particular on small businesses and nonprofits will be significant. Most of these small businesses and small nonprofits are so focused on surviving and keeping their doors open, and despite all of our outreach and attempts to educate them, are either unaware of this legislation, or if they're aware of it, don't really understand the impact it has on them. Many people have concerns, including earlier, Mrs. Vaughn noted that there are legitimate concerns regarding this legislation. It's burdensome. There's issues and cost issues to businesses and nonprofits. We agree. And as was earlier noted, it's not no big deal to businesses. We proposed the establishment of a new legislative work group this summer to work on and discuss the issues both sides have regarding this legislation. We suggest working together to get all this legislation working right for everybody. And so with that, I respectfully ask for an unfavorable report on both House Bill 8 and 496. And thank you for your consideration.
Thank you, sir. Fiona Ong.
Thank you for allowing me to speak today. I'm Fiona Ong, and I'm here today at the invitation of the Maryland Chamber of Commerce, for whom I serve as general counsel. I'm also a partner at a labor and employment firm that works with Maryland businesses of all sizes. And one area that takes up a lot of my time and attention is employee leave. These bills state that they're creating an insurance program to provide benefits for covered leave, and we're not philosophically opposed to this concept, but the actual language of both bills is unclear as to whether they are truly just providing pay for existing leave, like some of the programs in other states, or if they are creating an entirely new bank of paid leave up to 24 weeks, 12 for the employee's own condition, and an additional 12 for family reasons, with an absolute right to reinstatement regardless of the employee's misconduct, performance, or economic difficulties for the employer. As drafted, the state takes over the employer's HR function, which is simply unworkable. The state approves the leave, the employer is forced to accept it, and has no ability to verify the need for leave, to challenge leave as fraudulent or abusive, or to take into account the impact of the leave, again, up to almost 6 months on business operations, and they must hold the job for that entire time. I've heard from the proponents that they want this to be a leave bill to make sure that employees have protected leave for certain family and medical reasons. And of course, paid sick leave was passed several years ago for this very reason. But beyond that, there are a number of laws that already provide unpaid leave to employees, including for smaller employers, that could be covered by a pay benefit. Beyond the Family and Medical Leave Act, there's also leave required as an accommodation under the Americans with Disabilities Act and state disabilities law, the Parental Leave Act, the Pregnancy Accommodations Law, and the Organ Donation Leave Law, among others. But what's critically important about these laws is that all of them balance the leave rights against the needs of employers, such as verification, challenging fraud or abuse, no automatic reinstatement, and even denying leave that poses an undue hardship or significantly interferes with business operations. And this is why it's critical to make clear that this program is a pay for leave program and not a paid leave program. And until then, we request an unfavorable report. Thank you.
Thank you, Delegate Walker.
Thank you. I just wanted to go back to the last gentleman, the first gentleman that spoke. He mentioned about making this a study, but I'm under the impression that Delegate Valderrama has had in bills like this for a couple years now. This hasn't been studied throughout you guys haven't done a proper study on this, been out everything on both sides?
If I might just interject and say this was studied in 2017 from a task force, and my predecessors before me, there have been meetings across the aisle and with the organizations. You could say I inherited it, but proud to carry the torch. And there's been conversations back and forth, and whether there's negotiation or not, like any significant measure, that's how I would answer your inquiry, Delegate Walker.
I knew my colleague had done her homework. I'm sure.
With all due respect, I think there's been some lip service over the last couple of years to businesses and input. And so I would respectfully say that we probably need another look at this.
Let me ask this, and I don't want to start the debate, but I'm a pretty business understanding guy. How do you say it's lip service when there's a whole task force done on this? Was there a task force done on this?
Yeah, in my opinion, I think there could have been some more input. There's been some new discussion about maybe limiting some of the time, 12 weeks versus 24 weeks. How do we pay for it? So that's, again, from my perspective. And
we're at 12 weeks, aren't we? I haven't seen anything.
24 weeks. Up to 24 weeks, Delegate, you can take.
It could be up to 24 weeks total, but that would be putting 12 and 12. You're saying there's no clarity on that. So we as a committee, we could clarify that.
I think that's one thing we'd like to talk about. Thank you. Yes.
Okay. And then I'll leave it right there, Mr. Vice Chair. Thank you.
Thank you, Delegate Howard.
Thank you. To the last gentleman that just spoke, you said that task force was put together in 2017?
I'm not familiar with when it was all.
I mentioned that, Delegate Howard.
2017. Was that before COVID or after?
It was before,
Okay,
but there have been
thank you.
conversations after.
Yeah, thank you.
All right, Mark Sini.
Good afternoon, Chairman Wilson and members of the committee.
Hey, sir, real quick, can I have you turn on your camera?
Sure. It says host disabled participant screen sharing.
Oh, you're not trying to screen share, sir. You're just trying to turn your camera on.
Okay, I think it's on.
Look
Hold on one second.
on your lower left, Mark.
Okay,
There you go, sir. Oh,
am I on?
well, you were for a split second.
Okay, hold on. How about
There you-
now? I'm clicking it on and then,
Well, you just got to click it once, sir. There you go.
okay, sorry about that. My name is Mark Sini. First of all, good afternoon, everybody. Chairman Wilson, members of the committee. My name is Mark Sini, and I'm the general manager at James Kurtz Inc., which is a group of 5 service stations in the Silver Spring, Maryland area, all of which do car repairs. And I'm here to testify in opposition to House Bill 8 and House Bill 496. I acknowledge that this bill has very lofty and noble aspirations, but I can say emphatically that if it were to pass, it could conceivably, cause us to be in a financial and logistical nightmare. For instance, if one of our cashiers were to take 12 weeks of sick leave or family leave, I'd either have to hire somebody off the street and ask them to work 12 weeks, which is pretty unrealistic, or I'd have to ask an existing cashier to work an additional 40 hours and pay them overtime. In either case, nobody wants to work 80 hours, and the business really can't afford 40 hours of overtime for 12 weeks. Another situation, which would be even more dire, would be if one of our technicians were to take off 12 weeks. We have 2 technicians at each of the stations. So if one of them took off, it would cut my revenue by 50% for 3 months, which would be tantamount to about $50,000 or $60,000. And moreover, it would be inconceivable to try to hire a technician for 3 months. Similarly, if one of my managers took off for 12 weeks, where am I supposed to find somebody to work for 12 weeks? The reality is I'm not going to. In all these scenarios, I'm required to bring back the original employee for whether they've been out 12 or 24 weeks, and then tell the temporary employee to go. So I know I don't speak for all small businesses, but I'm sure I speak for many in saying that if the bill were to pass, it has the potential to put me into financial pain and also a lot of chaos in terms of scheduling. It's very hard in this business to hire anybody, period, but to be put in a position where we have to hire somebody temporarily and then tell them after 12 weeks or however long it is that they're no longer needed would be a fool's errand. There's no farm system for cashiers.
Sir, not to cut you off, but I'm going to need you to start to wrap up.
Okay, this is it. There's no farm system for cashiers or technicians or managers. And these are the reasons why I oppose House Bill 8 and House Bill 496. Thank you.
Thank you. Chris Costello.
Okay, can you hear me now?
I can hear you, sir.
Good afternoon, Committee Chair Wilson and Vice Chair Crosby. Chris Costello on behalf of the Howard County Chamber. Chamber members are supportive of the FMLA program concept. Many chamber members offer very generous benefits of this sort, and some that will enable them to qualify for the opt-out provision. But there are some problems in this bill, both bills, that we think should be addressed if you're going to go forward with this. The opposition is in 2 categories: the way the costs are set up. In addition to the assessments of the benefits, there's an additional time and expense for compliance with the laws and regulations. And for some businesses, this would be a blip, it wouldn't be noticed. But the statute applies to all employers in Maryland, 57% of which have fewer than 4 employees and are unlikely to be as sophisticated as an employer with even 15 employees. For many employers, this mandated benefit will be in addition to Maryland Healthy Working Families Act, the Maryland Parental Leave Act, the Maryland Flexible Leave Act, and on top of increases in minimum wage. So you can see where all of this is coming within the past few years. So it seems like an onslaught of additional costs and regulations. It seems almost overwhelming to some employers. The predictability is the other classification that we think you ought to take a look at to try and improve things if you're going to put this bill in. And that's a significant factor when the employer would return to work. And that's been addressed here. There are eligibility discrepancies. The leave should be required to be taken in concurrently with the FMLA. The two should run concurrently. If you did that, it'd be a great improvement in the bill. Having 24 weeks of leave in a year, if that were to take place, and no doubt it, in some cases it would, would be unacceptable and very dangerous for some employers of one or two people in a 4 or 5 person shop. Would put them in a very bad situation. The fact that they're not being paid.
Not to cut you off, sir, but I need you to start to wrap up.
We are. We would like to see this bill improved. We're not opposed to the concept, but thank you very much.
Thank you, Kelly Locklear.
Good evening, honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Association in opposition to this legislation. So a couple of points to make. The task force that reported out in 2017 looked at an employee paid fund. And 5 of the states that have paid family and medical leave are in fact employee paid. This has been one of our biggest issues with this policy since conversations began. But unfortunately, both of these bills are still written as an employee-employer split. We would also want to see the definition of family member and employer eligibility line up more with FMLA. Both bills actually allow for up to 24 weeks of leave in some instances, which raises concerns about solvency. We'd prefer to see a 12-week annual leave cap. As there, and everyone's talked about it, are significant challenges as someone being gone that long. And this committee is aware, but there are more job openings in Maryland than Marylanders to work in them. And so the more leave we're providing folks, this is going to exacerbate that problem. We also want to push out implementation for the bills as they take effect June of this year. We've seen many states, Washington and Massachusetts, make last-minute changes to the program, and that makes it very difficult for employers to prepare for implementation. And finally, as further proof of the importance of the implementation date and solvency issues that we've been bringing up, Washington State's fund is likely to already hit a deficit in March. So not only are these programs extremely expensive to set up, the estimate in our fiscal note is $20.8 million, but solvency is a real issue. There is even a recent piece of legislation in Washington to just add state funds to the program because they keep increasing the tax and they can't keep their funds solvent. So for these reasons, we continue to oppose this legislation, and we are always glad to work with the committee. Thank you.
Thank you. Kirk McCauley.
Good afternoon, Vice Chair Crosby, members of the committee. I represent WMDA, service stations, convenience stores, and repair facilities with over 700 members. Employee contributions is part of it, of HB 8, but it's a small part of our concerns. The lost revenue and cost to pay overtime is an elephant in the room. Some of my members have already talked about what time and a half costs, but a $15 an hour employee that was paid overtime for 12 weeks would cost that employer $3,600 in extra cost. That's just unacceptable. They can't handle that. That's if just one employee was out. And when a technician goes out, Mark was talking about it, they lose a significant portion of their income. We're not talking about overtime. We're talking about a lot of money. They could become insolvent pretty quick with multiple choices. And when you talk about 24 weeks, it kind of gets ridiculous, to tell you the truth. There's no balance in this bill. Work 17 weeks and get 12 to 24 off. Well, that's a pretty sweet deal. Actually, you could get a temporary employee to come to work and be working 24 weeks. And at 17 weeks, he could take off and get 12 weeks leave. I mean, it's just, some things just don't make sense. The concept of the bill, I think we can get behind. It needs a lot of work on it. But we agree that military, parental leave, that's all something that could be worked on. But the definitions, like Kaylee said, should go back and follow closely more lines with the federal leave. And I'll leave it at that. You all have my written testimony. Thank you. And we would like an unfavorable report.
Thank you, sir. Delegate Charkoudian.
Thank you, Mr. Vice Chair. I just had a quick question. There's 9 states plus DC that have a program along these lines. Obviously, the details matter. Kaylee, you were raising, Ms. Locklear, you were raising the issue of Washington State. Are there other states that besides Washington State that have challenges with those issues you raised?
So the reason that state in particular is having those problems is they created this fund from scratch. Many of the other funds, as you're aware, are drawing from other areas in their budget. And so this is something we've been watching over the years to figure out what solvency would look like there and how long it would take. So that's one of the main drivers behind the problems with solvency there.
So they're the only state that has the solvency problem, and they also started in 2020, right? So right when the pandemic was hitting, so leave was different and contributions were different, and unemployment was kind of messing up what we might see happening now that we're in a more stable economy. Isn't that so? Thank you, Mr. Vice Chair.
Thank you. Delegate Mounts.
Thanks, Chairman. I'll be quick. The question's for Kirk. Kirk, do you think this type of program would be beneficial for any of your employees whose wages are being garnished, if they could opt in or opt out?
That'd be a hard question for me to answer, because I represent an organization as a group, and I'm really not privileged to their individual things. But
I'll pose that to Kaylee. So Kaylee, for employees whose wages are garnished for various reasons, court-ordered garnishment, so their paycheck is about half of what it's supposed to be. This would be another deduction on their paycheck. Would it be better for them to have an opt-in or an opt-out type setting, or would the benefits of this program outweigh the further garnishment of their wages?
Thank you for the question, Delegate Mounts. So you're not giving employees an option here, right? If an employee just doesn't want access to this at all because they have, say, a long-term care insurance policy or whatever it is, it doesn't matter. They have to pay into this fund. So to your point, yes, that employee is going to see less of a paycheck on top of wage garnishment issues.
I just get a lot of complaints about, child support or other court-ordered reductions in paychecks, and they can't afford anything once the government takes what they've earned. Anyway, thanks.
Thank you. Bruce Spencer.
Hi, everybody. Thank you for having me. And a couple of the folks before me were in similar businesses, so I'll try not to be redundant with some of it. But I would just take the 2 hats here. One, as a business owner, we're a small business here in Severn. We're an auto repair shop. But I would ask the committee to put on the hats of all the trades. And I'll give you the example. So whether it's an HVAC contractor, an electrician, a plumber, or an auto repair shop, we bill our labor as our revenue source. And so if you take, and we talked about the data of very, very small businesses, these are 3, 4, 5 person operations in many cases. And when you take 1 or 2 people out, you're discounting the revenue of that organization. For instance, we have 4 technicians. We take 1 out, that's 25% of revenue gone. The thought of temporary workforce in a very skilled position is almost non-existent. It's not like we could fulfill that in a temporary role. So please consider that when you're looking at it from a revenue standpoint for the small businesses. Certainly the pandemic showed that if you were to be out without 25 or 40% of your business, we're really in harm's way as a small business. So thank you for consideration there. The other thing is if you're putting on your employee hat and you're being forced into a 0.75% roughly deduction in your pay that's forced upon you, the inclination of people who are forced to pay certain things, I think just human nature is if I have to pay for it, I'm more inclined to try to find a way to use it. Now, that lends itself towards a bit of abuse. I don't want to think that in people, but I think the nature of people certainly could fall into that of, hey, I'm being forced to do this and I'm going to find a way to use it. So please consider those. Other people have much more intelligent input, but I'm just trying to give you the perspective of a small business owner. And, you know, we're not that far from going out of business on any given month, year. Okay, please, I beg you that position of you. Thank you.
Thank you. Andrew Griffin.
Good evening, Mr. Vice Chair, members of the committee. Andrew Griffin here on behalf of the Maryland Chamber of Commerce. I know it is late. You have my lengthy testimony, so please, I encourage you to read it. And so I will be quick. The central piece of opposition here for the chamber is that if this bill were to pass as presented, it would be the only leave bill at the federal or state level in which the employer would not retain any right at all whatsoever to manage the leave of their employees. We're talking about 12 up to 24 weeks in which an employee would retain an absolute right to leave without any input or negotiation with the employer. That is a major problem, particularly in the current labor market we're experiencing, which you've heard of just before me from small businesses, to challenge particularly skilled labor and those that require certain education and certifications. That absolutely needs to be worked out. And it was also just mentioned, not to put too fine of a point on it, what we've seen in some other states, but also referencing what we've experienced here, since this is commonly compared to our state's unemployment insurance trust fund. If we're going to do this, you have to get it right. There needs to be some sense of an independent actuarial analysis of what this fund is going to look like. What are the reserve amounts that are needed to make sure we can make 1 year's worth of benefit payments? I'm glad to see some of the basic measures were included, which we've been asking for the last 4 or 5 years in this year's fiscal note. But there certainly isn't a suggested reserve level, which we would like to see. And I think that needs to be done certainly before any program is passed. So with that, I will conclude my remarks. I'm happy to answer any questions, urge an unfavorable report on both bills, and appreciate your time.
Thank you. Paige Bohan.
Good afternoon, Honorable Chair Wilson, Vice Chair Crosby, and Economic Matters Committee. I'm Paige Bowen. Respectfully, I'm here to oppose HB 8 and HB 496. My witness testimony is coming from the following point of view. First and foremost, I'm a volunteer leader. I play a volunteer leadership role for the Maryland SHRM State Council as Director of Government Affairs elect, and I'm also a senior HR practitioner with over almost 15 years of experience working for a company with over 100 employees in the state of Maryland. Maryland SHRM State Council is an association representing more than 7,000 members in our state. As HR professionals, we are committed to supporting legislation which will help Maryland employers recover economically to sustain employment opportunities and facilitate new job growth for Marylanders. A few outside considerations here. At least 9 states have enacted paid family and medical leave laws, but 2 of the 9 apply only to public sector. None of the 9 states border the state of Maryland. New Hampshire's governor had vetoed their state bill, and the state is moving forward with 100% voluntary paid leave. Maryland employers are currently required to provide up to 13 different types of paid and unpaid leave, which is becoming challenging in the HR field. That's including the sick and safe leave and also AD&A in particular leave as a reasonable accommodation under Americans with Disabilities Act. A few concerns I have with this bill, it would be the leave tax paid leave onto existing leave. That's already been mentioned as a concern. And so especially for some of the favorable witnesses who already promoted their own employers' paid leave policies, this could actually have unintended consequences for those employers and maybe cause cheapening of competitive benefits. From my practitioner point of view, it has been a challenging year for HR professionals. Leave being a primary focus. HR folks rose to the occasion to manage FFCRA mandated leave and then further managed what to do after that leave was no longer mandated. Many companies chose to voluntarily continue the leave. There were many challenging conversations with employees about vetting that leave. We remained adaptable and nimble, but it was not easy to keep up with the burdens placed on us from a compliance, communication, reporting, and tracking standpoint, literally overnight.
Ma'am, not to cut you off here, but I'm going to need you to start to wrap up.
Okay. Yep. And so the only other thing I would point out is employers already offer short-term disability employee policies many times as part of their total rewards benefit. And could we just, continue keeping that as a competitive option for employers? Thank you.
Thank you. Kenneth Kwasny. I do not see him in the chat. That is all the unfavorables on House Bill 8. We do thank, or I would like to publicly thank Delegate Valderrama for bringing the shorter of the two bills. Going to the remaining unfavorables, I think this is the last witness of the day, which is Mike O'Halloran.
Oh, that's an awful lot of pressure,
Good
Mr.
luck.
Vice Chairman. So I'll speed it
Start
up.
the timer.
And first, my apologies. I did, in fact, mean to sign up in opposition to both bills. No disrespect to Delegate Valderrama. For the record, my name is Mike O'Halloran, representing NFIB in Maryland, here in opposition to House Bills 8 and 496. Look, a record number of employers are raising their compensation, according to NFIB's latest jobs report, 50%, in fact. This being done on the heels of an economic crisis we haven't seen in nearly 100 years. One could safely assume that raise is not limited to wages, nor would it be a jump to realize a leave benefit as generous as what's called out for in these bills, and at the associated cost is also out of reach. So respectfully, I don't understand the advocates' arguments that small businesses who cannot afford to provide paid leave as it stands will now have the money to provide it under these bills. But know that many employers provide time off in some shape or form, notwithstanding what they are required to under the state's sick and safe leave law. Further, an employee utilizing this benefit does not somehow equate to savings for an employer. Small businesses like Mr. Cini's or Spencer's offer on-demand jobs, which means the work needs to get done by someone. So they're paying a different worker overtime or training and hiring a replacement. It's not a savings at all. Supporters contend the cost to the average employee will be about $3.62 per week. From an employer's vantage, one with 20 employees, for example, is paying $72.40 per week, which then equates to $3,764.80 per year. That is a substantial line item and a labor cost that in all likelihood will increase if the experience in other states serves as an example when it comes to the solvency of the funds. The fact is, small business owners will do everything they can to accommodate the needs of their employees, especially when it comes to caring for family members in need of palliative care. But when it's shaped and required in such a one-size-fits-all manner as these bills, that is not something small business owners can afford. As for this program being a tool for small businesses, it's not a tool our members want. 80%, in fact, when they were surveyed. The tools they need are improved infrastructure, access to broadband, and affordable and predictable health insurance they can offer their employees. Fixed labor costs like HB 8 and HB 496 can be solved, but I guarantee you the solution is not good for workers or employers. Outsourcing, automation, and less jobs is not something our members want to do. For these reasons, we respectfully request an unfavorable report. Thank you.
Mike, the chair appreciates you only opposing his bill.
I'm an equal opportunist, sir.
Yeah. So quickly, I know that I've probably received 50 text messages from individuals, and I just want to make it clear that unless you properly sign up to testify one way or the other, both favorable or unfavorable, that is the only way we can call you so that you can testify. So I'm not trying to be a complete stickler on this.
Sure.
No, this isn't for you, Mike. You did it properly. That's why we called on you. It's all right. You can go on mute. You don't have to pose anything else. But just for everybody else's awareness, you have to properly sign up before the deadline to testify on the bill, whether favorable or unfavorable. So just going forward, make sure that you have conducted or properly done that, so that way we can call you. That does conclude the House or the bill hearings for today. Tomorrow, 10 a.m., we have the subcommittee meeting, and then at 12 noon, we have a voting session. So thank you all. I know it was a long day and appreciate everybody hanging in there. Take care.